Senate will come to order. Calling motion in writing.
Motion in writing. Mr. President, I move suspension of Senate Rule 5.14, the intent calendar rule, in order to move the intent calendar deadline to 8:00 p.m. today. I further move that the rule be suspended to allow the Secretary of the Senate to make the calendar available as soon as practicable. Motion by Zaffarini.
Is there any objection? Hearing none, motion is adopted. Senator Hagan-Boo, you're recognized for a motion to suspend the regular order of business on House Bill 2128.
Thank you, Mr. President. Members, HB 2128 is a bill I'm sponsoring for Representative Spiller that has to do with rural firefighting in rural communities, often lack the right resources and infrastructure available to urban municipalities, leaving them ill-equipped to effectively respond to emergencies. HB 2128 requires the Texas A&M Engineering Extension Service to conduct a study of technical rescue service capabilities of rural versus urban areas within the state of Texas. This bill seeks to provide a comprehensive understanding of the challenges faced by rural fighting and rescue services, with the goal of identifying potential solutions to improve their effectiveness and sustainability. Hopefully, in the interim, we can examine this study to see what changes need to be made to help our rural departments continue to serve our citizens. With that, Mr. President, I move suspension of the regular order of business.
Senator Hagan-Boo moves suspension of the regular order of business on House Bill 2128. Is there objection? Hearing none, the rules are suspended. Chair lays out on second reading House Bill 2128. The Secretary will read the caption.
House Bill 2128 relating to a study of rural firefighting and technical rescue service capabilities.
Senator Hagan-Boo, you're recognized for a motion.
Move passage third reading.
Senator Hagan-Boo moves passage to third reading. Is there objection? Hearing none, the bill is passed to third reading. Senator Hagan-Boo, you're recognized for a motion to suspend the constitutional 3-day rule.
So moved.
Senator Hagan-Boo moves suspension of the 3-day rule. The Secretary will call the roll.
Alvarado, Betancourt, Boardwell, Blanco.
31 ayes, 0 nays. Rules suspended. Chair lays out on third reading. Final passage, House Bill 2128. The Secretary will read the caption.
House Bill 2128 relating to a study of rural firefighting and technical rescue service capabilities.
Senator Hagan-Boo, you recognized for a motion.
Move final passage.
Senator Hagan-Boo moves final passage. House Bill 2128. The Secretary will call the roll.
Alvarado, Betancourt, Boardwell, Blanco,
31
Campbell.
ayes, 0 nays. Bill is finally passed.
Thank you, Mr. President. Thank you, members.
Senator Hinojosa of Nueces, you are recognized for a motion to suspend the regular order of business on House Bill 4157.
Thank you, Mr. President. I move to suspend the regular order of business to take up and consider House Bill 4157. House Bill 4157 aligns Texas law more closely with federal regulations and mirrors similar statutes in Florida, a key competitor in the space industry. The bill allows employees of spaceflight companies to voluntarily waive their right to bring claims against their employer without affecting their rights under workers' compensation laws. It also formally recognizes reciprocal waivers, which are already required under federal law, ensuring they are upheld in state court. This update brings Texas law in line with 14 CFR Part 126, which governs cross waivers for space operations, including those related to the International Space Station and future federal regulations. As space transportation emerges as a new frontier for Texas, this bill helps maintain our state's competitiveness by adopting consistent legal standards. And with that, Mr. President, I move suspension.
Senator Hinojosa moves suspension of the regular order of business on House Bill 4157. There is objection. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco.
28 ayes, 3 nays. Rule is suspended. Chair lays out on second reading House Bill 4157. The Secretary will read the caption.
House Bill 4157, relating to liability protections for commercial space flight and exploration.
Senator Hinojosa, you're recognized for a motion.
Thank you, Mr. President. I move passage to third reading.
Senator Hinojosa moves passage to third reading. There is objection. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
28 ayes, 3 nays. Bill is passed to third reading. Senator Hinojosa, you're recognized for a motion to suspend the constitutional 3-day rule.
Thank you, Mr. President. So moved.
Senator Hinojosa moves suspension of the 3-day rule. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco.
28 ayes, 3 nays. Rule suspended. Chair lays out on third reading and final passage House Bill 4157. The Secretary will read the caption.
House Bill 4157, relating to liability protections for commercial space flight and exploration.
Senator Hinojosa, you're recognized for a motion.
Thank you, Mr. President. I move final passage of House Bill 4157.
Senator Hinojosa moves final passage House Bill 4157. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
28 ayes and 3 nays. Bill is finally passed.
Thank you, Mr. President, and thank you, members.
Senator Zaffarini, you're recognized for a motion to suspend the regular order of business on House Bill 2240.
Thank you, Mr. President. Mr. President, members, House Bill 2240 by Representative Harold Dutton relates to certain void marriages. Members, under current law, a marriage is not valid if one of the spouses is legally married to someone else. Once the earlier marriage ends, the new marriage becomes valid if the spouses live together and represent themselves to others as married. House Bill 2240 would provide needed protections to innocent spouses, ensuring they aren't misled into invalid marriages with spouses also married to someone else. Generally then, House Bill 2240 would allow innocent spouses to ensure their marriage does not become valid if they did not know the guilty spouse was already married when the later marriage began, have not lived as spouses or claimed to be married since learning of their spouse's marriage, and files to void the marriage within 30 days of learning about their spouse's prior marriage. And there is an amendment by Senator Birdwell that takes care of the military services members. Mr. President, I move suspension.
Senator Zaffarini moves suspension of the regular order of business on House Bill 2240. Is there objection? Hearing none, the rule is suspended. Chair lays out on second reading House Bill 2240. The Secretary will read the caption.
House Bill 2240, relating to certain void marriages.
Following amendment, Secretary read the amendment.
Floor Amendment number 1 by Birdwell.
Senator Birdwell, you're recognized.
Thank you, Mr. President. Members, thank you, Senator Zaffarini. Members, this amendment is intended to accommodate active duty military service member, active foreign service officers, or Texas military forces in active state or federal service. The putative spouse has 30 days after the discovery of their spouse's marriage, according to the bill, to file for the voiding of their marriage. That 30-day window does not factor in the additional time that may be needed for individuals who are serving overseas or actively deployed in the state for an emergency. The amendment would retain the 30-day window, but make it a 90-day window for either the putative spouse or the respondent if they're on active duty in the United States Armed Forces, the Foreign Service of the State Department, or on active duty in the Army National Guard or Air National Guard for a state emergency. The amendment ensures that those service members have time to file, and I believe it's acceptable to the author. I would move adoption, Mr. President.
Senator Zaffarini, recognized.
It is acceptable to the author.
Questions on the adoption of floor amendment number 1, acceptable to the author. Is there any objection to the amendment? Hearing none, amendment's adopted. Senator Zaffarini, recognized for a motion.
Thank you, Mr. President. I move passage to third reading.
Senator Zaffarini moves passage to third reading. Is there objection? Hearing none, the bill is passed to third reading. Senator Zaffarini, recognized for a motion to suspend the constitutional 3-day rule.
Thank you, Mr. President. I move to suspend the constitutional rule that bills be heard on 3 several days.
Senator Zaffarini moves suspension of the 3-day rule. Secretary, call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
30 ayes and 1 nay. The rule is suspended. Chair lays out on third reading. Final passage, House Bill 2240. The Secretary will read the caption.
House Bill 2240, relating to certain void marriages.
Senator Zaffarini, recognized for a motion.
Thank you, Mr. President. I move final passage.
Senator Zaffarini moves final passage, House Bill 2240. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
30 ayes and 1 nay. The bill is finally passed.
Thank you, Mr. President and members.
Senator Menendez, you're recognized for a motion to suspend the regular order of business on House Bill 367.
Thank you, Mr. President. Members, in the 87th regular session, we passed a bill titled Riley's Rule, which stated that students should qualify for excused absences even in the event of a serious illness. The purpose was to support medically vulnerable students who should not have to choose between tending to their health and passing to the next grade simply because of missed class periods. What House Bill 367 does, it clarifies Riley's Rule by requiring that school districts adopt a standard form with all of the necessary information to excuse these absences. School districts cannot ask for any information not included on the form. Among the information necessary is the name of the illness, the severity, how long it's expected to last, and that it makes the student incapable of attending school, all of which is required to come from a physician. Finally, TEA will create a model of this form and post it on their website. With all these things, I move suspension of the regular order of business to take up and consider House Bill 367.
Senator Menendez moves suspension of the regular order of business on House Bill 367. Is there objection? Hearing none, the rules are suspended. Chair lays out on second reading House Bill 367. The Secretary will read the caption.
House Bill 367, relating to verification of excused absences from public school for students with severe or life-threatening illnesses.
Senator Menendez, you're recognized for a motion.
Mr. President, I move passage to third reading.
Senator Menendez moves passage to third reading. Is there objection? Hearing none, the bill is passed to third reading. Senator Menendez, you're recognized for a motion to suspend the constitutional 3-day rule.
So moved.
Senator Menendez moves suspension of the 3-day rule. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco.
31 ayes, 0 nays. Rule is suspended. Chair lays out on third reading. Final passage, House Bill 367. The Secretary will read the caption.
House Bill 367, relating to verification of excused absences from public school for students with severe or life-threatening illnesses.
Senator Menendez, you're recognized for a motion.
Mr. President, I move final passage of House Bill 367 by Representative Rosenthal.
Senator Menendez moves final passage. House Bill 367. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
31 ayes, 0 nays. Bill is finally passed.
Thank you, Mr. President. Thank you, members.
Senator King, you're recognized for a motion to suspend the regular order of business on House Bill 1506.
Thank you, Mr. President. Under current law, the expedited process through which a retired judge may obtain a license to carry only applies to certain visiting judges, senior judges, or retired federal judges who are Texas residents. Other retired judges, such as those who served as a county judge or a district judge, have expressed the desire to be included in the definition of retired judicial officer for obtaining an expedited license to carry, and that's what this does. Move suspension.
Senator King moves suspension of the regular order of business on House Bill 1506. Is there objection? Hearing none. Rules are suspended. Chair lays out on second reading House Bill 1506. The Secretary will read the caption.
House Bill 1506, relating to the issuance of a license to carry a handgun to certain retired county court judges.
Senator King, you're recognized for a motion.
Move passage, third reading.
Senator King moves passage to third reading. Is there objection? Hearing none, the rule is passed to third reading. Senator King, you recognized for a motion to suspend the constitutional 3-day rule.
So move.
Senator King moves suspension of the 3-day rule. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco.
29 ayes, 2 nays. Rule is suspended. Chair lays out on third reading final passage House Bill 1506. The Secretary will read the caption.
House Bill 1506, relating to the issuance of a license to carry a handgun to certain retired county court judges.
Senator King, you're recognized for a motion.
Move final passage.
Senator King moves final passage House Bill 1506. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
29 ayes and 2 nays. Bill is finally passed.
Thank you, Mr. President and members.
Senator Sparks, you're recognized for a motion to suspend the regular order of business on House Bill 4449.
Thank you, Mr. President. Members, I move to suspend the regular order of business in order to take up and consider House Bill 4449. Under current law, when a city annexes new territory, its alcohol status doesn't automatically apply. This creates challenges for growing communities where inconsistent alcohol regulations can deter restaurants and retailers from investing in annexed areas. House Bill 4449 allows alcohol status in one community in my district to automatically extend to annexed areas, promoting regulatory consistency and supporting economic development. With that, I move suspension.
Senator Sparks moves suspension of the regular order of business on House Bill 4449. Is there objection? Hearing none, the rules are suspended. Chair lays out on second reading House Bill 4449. The Secretary will read the caption.
House Bill 4449, relating to the sale of alcoholic beverages in areas annexed by certain municipalities.
Senator Sparks, you're recognized for a motion.
Thank you, Mr. President. I move passage to third reading.
Senator Sparks moves passage to third reading. Is there objection? Hearing none, the bill is passed to third reading. Senator Sparks, you're recognized for a motion to suspend the constitutional 3-day rule.
So moved.
Senator Sparks moves suspension of the three-day rule. The secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco.
29 ayes and 2 nays. Rule suspended. Chair lays out on third reading, final passage, House Bill 4449. The secretary will read the caption.
House Bill 4449 relating to the sale of alcoholic beverages in areas annexed by certain municipalities.
Senator Sparks, you are recognized for a motion.
Thank you, Mr. President. I move final passage for House Bill 4449.
Senator Sparks moves final passage, House Bill 4449. The secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
29 ayes and 2 nays. The bill is finally passed.
Thank you, Mr. President. Thank you, members.
Senator Hancock, you are recognized for a motion to suspend the regular order of business on House Bill 3812.
Yes, thank you, Mr. President. I move to suspend the regular order of business, take up and consider House Bill 3812 at this time. House Bill 3812 streamlines the gold card process to make improvements for the prior authorization system and requires additional reporting for the health plans that will allow TDI to enforce the law. With that, I move suspension.
Senator Hancock moves suspension of the regular order of business on House Bill 3812. Is there objection? Hearing none, the rules are suspended. Chair lays out on second reading House Bill 3812. The secretary will read the caption.
House Bill 3812 relating to health benefit plan pre-authorization requirements for certain health care services.
Senator Hancock, you're recognized for a motion.
Move passage of House Bill 3812 to third reading.
Senator Hancock moves passage to third reading. Is there objection? Hearing none, the bill is passed to third reading. Senator Hancock, you're recognized for a motion to suspend the constitutional three-day rule.
So moved.
Senator Hancock moves suspension of the three-day rule. Secretary will call the roll.
Alvarado, Betancourt, Birdwell,
30
Blanco.
ayes and 1 nay. The rule is suspended. Chair lays out on third reading. Final passage, House Bill 3812. The secretary will read the caption.
House Bill 3812 relating to health benefit plan pre-authorization requirements for certain health care services.
Senator Hancock, you're recognized for a motion.
I move final passage.
Senator Hancock moves final passage, House Bill 3812. The secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco.
30 ayes and 1 nay. Bill is finally passed.
Thank you.
The chair announces the signing of the following in the presence of the Senate.
Senate Bill 2037, Senate Bill 20, Senate Bill 33, Senate Bill 75, Senate Bill 213, Senate Bill 227, Senate Bill 269, Senate Bill 458, Senate Bill 528, Senate Bill 647, Senate Bill 648, Senate Bill 681, Senate Bill 740, Senate Bill 835, Senate Bill 840, Senate Bill 843, Senate Bill 1061, Senate Bill 1120, Senate Bill 1121, Senate Bill 1150, Senate Bill 1202, Senate Bill 1253, Senate Bill 1423, Senate Bill 1535, Senate Bill 1574, Senate Bill 1709, Senate Bill 1789, Senate Bill 2078, Senate Bill 2544, Senate Bill 2570. House Bill 388, House Bill 413, House Bill 519, House Bill 609, House Bill 685, House Bill 766, House Bill 1422, House Bill 1445, House Bill 1458, House Bill 1481, House Bill 1562, House Bill 1586, House Bill 1592, House Bill 1606, House Bill 1612, House Bill 1633, House Bill 1732, House Bill 1828, House Bill 1851, House Bill 1916, House Bill 1991, House Bill 2014, House Bill 2025, House Bill 2026, House Bill 2061, House Bill 2856, House Bill 3062, House Bill 3114, House Bill 3120, House Bill 3180, House Bill 3214, House Bill 3234, House Bill 3505, House Bill 3597, HCR 10, HCR 127, HCR 130, HCR 131, HCR 133, HCR 134, HCR 135, HCR 139, HCR 140, House Bill 3680, House Bill 3732, House Bill 3745, House Bill 3801, House Bill 3803, House Bill 3804, House Bill 3806, House Bill 3833, House Bill 4044, House Bill 4129, House Bill 4224, House Bill 4230, House Bill 4377, House Bill 4395, House Bill 4396, House Bill 4668, House Bill 4738, House Bill 5084, House Bill 5149, House Bill 5155, House Bill 5180, House Bill 5436, House Bill 5667, House Bill 5686, House Bill 5688, House Bill 5693. House Bill 49, House Bill 75, House Bill 108, House Bill 128, House Bill 201, House Bill 272, House Bill 551, House Bill 621, House Bill 661, House Bill 2073, House Bill 2193, House Bill 2253, House Bill 2259, House Bill 2273, House Bill 2282, House Bill 2293, House Bill 2294, House Bill 2306, House Bill 2310, House Bill 2358, House Bill 2421, House Bill 2464, House Bill 2508, House Bill 2518, House Bill 2524, House Bill 2530, House Bill 2563, House Bill 2593, House Bill 2674, House Bill 2713, House Bill 2715, House Bill 2761, House Bill 2791, House Bill 3010, House Bill 3151, House Bill 3159, House Bill 3254, House Bill 3284, House Bill 3627, House Bill 3928, House Bill 3940, House Bill 4063, House Bill 4281, House Bill 4454, House Bill 4666, House Bill 4743, House Bill 5308, House Bill 5394, HCR 108, HCR 118, HCR 142, HCR 143, HCR 147, HCR 152, HJR 133.
Senator Paxton, you're recognized for a motion to suspend the regular order of business on House Bill 521.
Thank you, Mr. President and members. I move to suspend the regular order of business to take up and consider House Bill 521. To help prevent misuse of curbside voting, House Bill 521 simply requires voters using curbside voting to sign an oath affirming their inability to enter the polling place without assistance or risk of injury. It establishes a 20-foot boundary around a designated curbside voting place where electioneering is prohibited, and it clarifies existing protocols by specifying that an election officer who delivers a ballot to a curbside voter may not assist in marking the ballot unless there is a second election officer present, just like is the case inside the polling station. It discourages fraudulent assistance activities by strengthening transparency in the reporting requirements for individuals who assist 7 or more voters during an election. This bill improves and preserves access for Texans who genuinely require curbside assistance. I move to suspend.
Senator Miles, for what purpose?
Mr. President, questions to the author of this bill?
Senator Paxton, do you yield?
Of course.
Senator Paxton, seems like we're having a little deja vu from a couple of sessions of the past as it relates to a lot of these voting bills. And I've got a few questions I'd like to clarify
Of course.
on House Bill 5521. And the first one would be, what is the importance of requiring voters who receive curbside ballots to complete a sworn form verifying their eligibility?
So, Senator Miles, I had sort of the same question. This bill, this House bill, came from
I'm
Representative...
sorry, I couldn't hear you. You said you asked the author the same question?
I said, and I'm sorry, I'm a little bit hoarse, so I'll hold the microphone close. I had the same question when I first looked at the bill. This came to us from Representative Guillen. And the reason that he carried this bill is because he said this is a very big problem in his district. And what he described to me was that there were many, many people that were using curbside voting like people use HEB grocery pickup. And of course, the problem there is that there aren't very many spaces allocated for curbside voting. Typically, you don't have a lot of people that need that, but you have maybe one or two places that are allocated. And what was happening is that there were people who just wanted to get kind of the fast pass and use the drive-through. And so that was the origin of this bill.
So, as I've said many, many times on this floor, I represent an elderly district. And curbside voting is something we use in my district quite a bit. And I wish we had actually more access to more curbside voting. So, does this require sworn affidavits for curbside voting? Doesn't it make it more difficult for voters needing assistance, this bill, instead of assisting them more?
It does not. And Senator Miles, I hear the heart of what you're saying, and I have a place for it myself. Because my mother was very infirm. She had mobility issues in her last years. And so I commonly would drive her to the polls and go in and ask them to come and do curbside voting for her. And so I understand the need for this. And it's one of the reasons that I think this bill is important, because it makes sense that when you're the person or you're helping a person that needs the curbside voting, the last thing you want is for that space to be occupied by someone who doesn't. But the way this would work is that the election officer would bring the statement, so they just sign it right there. It's not a difficult thing for them to do.
Well, you would need more, and that's why I'm thinking adding more steps for curbside voters and their helpers affect voters' access and election operations. Don't you agree with that too? Because you're stretching out the distance. You're making it have to go further, which is going to slow it down even further.
I don't know that I understand what you're saying about making someone go further.
In the bill, it's asking for curbside voters' helpers to have more space, and it's going to be further away.
Are you talking about the 20 feet?
The turn point, yes.
The 20 feet applies to electioneering. So, when we go to the polls, there's a big yellow sign that's posted. And so this is to prevent electioneering. It's to prevent the folks who are curbside voting from, being electioneered while they're sitting there waiting. And so it doesn't do anything to make something more difficult for the people that are wanting to curbside vote. And it doesn't change anything for the election workers. The election workers can still have that spot or spots wherever they usually have them. It just creates a space around the curbside voting spaces.
So let me ask you something. In our election code, does it not already establish that there's a penalty for breaking or for missing forms or breaking proximate rules, footage rules, foot rules? Isn't that already part of our election code?
Well, what this will do, Senator Miles, is it will document these things. So someone can, one of the things that's difficult about this, and you can imagine this, if you're a poll worker and you walk up and you see, you know, a strong young guy in a muscle shirt, right? You may not think, and he's trying to curbside vote. And it puts it in a very difficult place for the election worker to tell someone, you can't curbside vote. It's really not it's a difficult thing for them to do that. So what this does is it really simplifies the process. It takes the subjectivity out of it, and it simply means that the poll worker or election judge would bring to the person who wants to curbside vote a form. When they're bringing everything else anyway, they would sign that, and then they would vote.
But isn't the distance markers and all that kind of stuff, isn't it already part of our election code?
The distance markers are, but this is to protect the curbside voting.
But now we're going to establish this. This bill establishes it as a Class A misdemeanor.
Yes.
If they violate, isn't that already part of the election code?
I'm going to take your word for it, sir.
Okay, let's move on. The bill, but just for the record, it is. But the bill's rationale for prohibiting an electioneer within a specific distance of the early voting entrance and curbside voting spaces. So all these things are already in our election code. And it just, I'm confused on why it is now that we're going to make this a Class A misdemeanor, when all we're trying to do is make sure that the people who need to get to the voting place, who may be disabled, who may have a bad back, who may be on walkers, things of that nature, make it easier for them to get to the polling places. Shouldn't we be doing that?
That's right, and that's what this bill does, Senator Miles. It's designed to make it easier for them to remove any sort of interference that they might encounter from people that are electioneering and give them the same kind of protections that the people who are standing in line have.
I hear you saying it, but this bill is saying something different, Senator Paxton. And, you know, in my neighborhood, we thrive. Our churches are big units in our communities, and we have something that's called, you know, Ride to the Polls, and our churches and our community people bring our elderly to the polling places. And I'm wondering, why must an individual who assists 7 or more curbside voters provide detailed information and complete official forms just to drive someone from the community who's elderly just to get them to the polls?
Well, I think we would all agree that signing your signature is a very small effort in order to ensure election integrity.
Well, it's not just a signed signature, it's a completion of forms. It's not just a signature, it's a completion of forms.
It's your name and your information.
Out.
Yeah, it's your name and your information. It's very simple. It's not an onerous burden whatsoever.
Lastly, Senator Paxton, the provision seems to be more of a burden on election workers and voters. Our goal should be to ensure that accessibility of our elections are present. And I think this bill creates a hurdle, more of a hurdle, and others, you know, may be seen by some, such as myself, as a bill of suppression and not of protection. Thank you, Senator Paxton. Thank you, members.
Thank you, Senator Miles. And we both share the goal of making sure that access is there, and this bill will help ensure that the right people who need the accommodation are able to get it in a timely way. Thank you, sir.
Senator Menendez, for what purpose?
Questions of the author, Mr. President.
Senator Paxton, do you yield?
I do.
Thank you, Mr. President. Thank you, Senator Paxton. I was listening and reading your bill at the same time, and the concern, I guess, on page 1, line 56, says here, before an election officer may deliver a ballot to a voter, under subsection A, the voter must complete and sign a form provided by the election officer.
And I'm trying to get there, Senator Menendez. I apologize.
Oh, that's okay, no problem.
Page 1.
So it's on page 1. It starts on line 56. Basically, it's outlining the process by which someone is allowed to vote curbside. And it says here, before that happens, the voter must complete and sign a form provided by the election officer that contains the following statement. So I guess it is Representative Guillen and your desire that they sign this form that says, I swear or affirm under penalty of perjury that I'm physically unable to enter the polling place without personal assistance or likelihood of injuring my health, or I am requesting reasonable accommodation under the section. Therefore, I'm requesting to vote outside of the polling place. So when they arrive, and I'm trying to figure out how this works, I'll give you an example. We have an old shopping mall in San Antonio. It used to be called Wonderland Mall when it was built way back in the 60s, and Crossroads switched back. The early voting polling site is in the interior of the mall, over by the food court. So you have to walk quite a bit of ways. How would someone, I guess when someone pulls up to curbside and they know they can't walk that quarter mile or so, 300-400 yards into the site, how would they get the form to let them know to come out? And then, how does this work? And I'm just kind of wondering, why do we want to do this? What's the public policy of doing this?
Well, and if you were listening to the exchange between Senator Miles and myself, I mentioned how this bill came over to us from Representative Guillen,
right,
who came up with this idea among folks there in his district because they have a problem. In the last election cycle, just recently, people have gotten used to picking up their groceries on the curb and that sort of thing. And he said literally that the curbside voting people were trying to utilize curbside voting kind of like a drive-through instead of standing in line. And so, again, the problem there is that, there are typically only a few places, maybe one, maybe two, that are allocated for the curbside voting. People that need curbside voting, right? Like my mom that I talked about. And so if someone is able-bodied and they're in that space, trying to use it like the drive-through,
right,
then or HEB pickup, then that's, of course, keeping someone else. That's the thing that's denying access. So we're trying to get rid of the interference from folks that don't need it.
Okay.
And from a practical standpoint, too, you brought up when the actual polling location is inside, it's a long distance away from the curbside. But in my experience with my mom, even if it was close, now I could get out of the car and walk in, right?
Right.
But what I always noticed was that at the curbside voting place, there was always a sign that said, if you need curbside voting, call this number.
Sure.
Because obviously someone that needs to curbside vote, even if it's 10 feet away to the door, they can't get up and walk in. So they have the ability they already kind of manage those kinds of things. And as another note, the Secretary of State's office has rulemaking authority on this to address any of the minutia that might come out of this on the.
So what is the penalty for a Class A misdemeanor? And I guess who would enforce or say that, let's say, someone has broken the law? I mean, I guess, I don't know. Who is going to say that if you went and filed that form, and does the election judge look at the person and say, hey, you could have walked in, or how do we enforce this?
So if the person fills out the form, then there would be a process for turning in that form. And I suppose, again, the Secretary of State will have rulemaking on that.
Okay.
I suppose if someone had a reason to believe that that was not accurate or not truthful, they could bring that to the attention of the Secretary of State.
Okay. And I don't recall, what is a Class A misdemeanor? What are the penalties for a Class A?
What is the penalty for Class C?
180 days?
Up to? Okay. For Class C misdemeanor?
I think your bill says Class A is what I read here.
Class A?
On page
That's Class
2.
A. I apologize, Senator Menendez.
Okay.
I believe that it is up to a year in jail, up to a $4,000 fine.
Up to a year in jail and up to $4,000?
Up to.
Up
That's
to
not the minimum. That is an up to.
Wow, a year, and that's for,
That is to make sure that able-bodied people are not taking up the
what is the
curbside
penalty
voting.
for having someone who's not eligible, doesn't have a handicap designation for parking in a handicap? Do we know?
Could you repeat? I couldn't hear.
If you park out your car, no one, let's say none of us are qualified to park
If
in
you
a
had a handicap and you violated that,
we violate. If we're in a rush, we want to go into the store before we pick up the curbside before Best Buy closes, and we park in the handicap, what is the penalty for violating that?
I'm not sure. Do you know?
I don't, and that's what I'm just trying to figure out. I mean, is a Class A misdemeanor up to a year in jail and $4,000, is it equitable? Because I agree with what you're trying to do. I'm just trying to be careful that we don't make criminal offenses that are disproportionate to what someone's done. Maybe for some reason, they were just not feeling well that day. I don't know why someone would do it. Obviously I like to go and stand in line, but maybe someone else wasn't feeling well that day. And my question or my fear is that if someone gets accused of violating this offense, this new criminal offense that you all are looking to put into the books, is a Class A, is that appropriate? Is that the appropriate?
And I don't, we both have agreed we don't know what the actual penalty is for parking in a handicap spot to go into Best Buy, but I think we would both agree that this is, preventing, keeping someone from being able to park, and there's usually several handicap spots, right?
Sure, agreed.
And they're going into shop, right?
Right.
Maybe some they really need, but we're talking here about a limited number of spots, usually one or two,
Right.
and it's keeping someone from voting.
Totally agree. I completely agree that only people who truly need to use curbside should use curbside. I just want to make sure that we don't raise a penalty. I mean, there are many of our colleagues in this room that vote against anything that raises anything that sounds like a tax or a fine or a penalty. And so I'm just saying this is going to create potentially send someone to jail or a $4,000 fine. I think we just need to be careful. Thank you for answering my questions.
Thank you, Senator Menendez. I
Thank you.
appreciate it.
Senator Paxton moves suspension of the regular order of business on House Bill 521. There is objection. Secretary will call the roll.
Alvarado, Betancourt, Bardwell, Blanco, Campbell.
21 ayes, 10 nays. Rule is suspended. Chair lays out on second reading House Bill 521. The Secretary will read the caption.
House Bill 521 relating to accommodating voters with a disability.
Following amendment. Secretary, read the amendment.
Floor Amendment Number 1 by Paxton.
Senator Paxton, you're recognized.
Amendment? All right. Thank you, Mr. President. Members, this amendment ensures that individuals who are assisting curbside voters by providing transportation are notified that they may need to fill out associated paperwork if they have assisted 7 or more curbside voters for the same election. This amendment was provided to our office by the Secretary of State's office in consultation with advocates for Texans with disabilities and the House author, Chairman Guillen. I move adoption of Floor Amendment 1.
Senator Menendez, for what purpose?
Thank you, Mr. President. I was just reading the amendment. I just had a question or two.
Senator Paxton, do you yield?
I do.
Thank you, Senator Paxton and President. I think in your layout you mentioned disability rights brought this amendment to you? Or was it in conjunction with the Secretary of State?
Let me double check that. It was done in consultation with advocates for Texans with disabilities and the House author, and it was provided to our office by the Secretary of State's office. And they did consult with Texans with disabilities.
So basically the amendment says that if you've brought 7 or more people to vote, that you have to fill out a form, sign a form, provided it contains the person's name and address, and whether the person's providing assistance solely under this section or under both section subchapter B. So you guys are creating, I guess this bill would create sort of a registry of people who help people come out to vote? Is that what this is?
I don't believe that this is meant to be some sort of a collection, but what this is, it's like everything else. It's for that moment to assess that the person is simply doing what they say they're doing. That they're driving.
That they're driving. So the election officer shall ask the person providing transportation whether the person has assisted 7 or more. So you get asked, the answer, let's say, is yes. Under this section, then, if you say, yes, I've done 7 or more, and I've assisted, then now I have to fill out a form. Who holds or keeps that form?
I believe it would be the election judge, and then that would be communicated to the Secretary of State's office.
Secretary of State here in Austin. So we have a lot of senior centers that a lot of people volunteer to take the seniors to vote. And what we're saying now is that if you are one of these volunteers driving seniors to vote, that you need to turn in your name, let's say name, address, and whether or not you're under section. Do we know how long the information's held at the Secretary of State's office?
It will be held at the Secretary of State's office, that's
In the
correct.
Secretary of State's, but do we know how long?
They have rulemaking authority on this, so they'll be determining that. I would say, though, I don't believe that the intent is to create some sort of registry.
It just seems like it has the capacity to create a database of people who drive seniors to vote, and what's the purpose of that? I mean, why are we doing that?
My staff is also telling me that this is actually cleanup language for existing law to the form and that sort of thing. So
Thank you for answering my questions.
thank you, Senator.
Senator Miles, for what purpose?
Purpose to the author of this amendment, Mr. President.
Senator Paxton, do you yield?
I do.
Senator Paxton, please explain to me the origin of this amendment. If I'm reading this correctly, you now want to keep a log and a data of the name, the person's address, who is actually transporting my seniors to the voting places? So they could be fearful of being targeted or harassed. That's what this amendment does. You want to keep a database. You want to keep records of where the person driving the van lives and their name? For what purpose?
So, Senator Miles, it is already the law, and Senator Menendez, I apologize, I didn't
And I'm sorry,
answer
Mr.
this
President.
way, but
It's not
Senator
the,
Miles?
Senator President, Mr. President, it's not the members. I can't, either her mic's not up, or I know you're a little sick and you got a little voice problem. So I want to hear, I want to make sure everybody
Absolutely.
hears this.
If we could, one at a time, please, and have some civility. Thank you. One at a time. Senator Miles, you're recognized.
Yeah.
so it is already the law that the driver has to fill out.
Senator Miles, you're recognized. Are you
You've already recognized me, Mr.
Are you
President.
through with your question?
You already recognize me. All I'm asking is her mic be turned up.
Senator Paxton, you're recognized.
Thank you, Mr. President. So, Senator Miles, it is already the law that the driver has to fill out this form. This actually cleans it up by just making sure that the election worker notifies the person that they have to fill out the form. So this actually creates a little more transparency for the driver. They let them know that they have to fill out the form.
Let them know that they don't have to fill out the form, or they do.
That they do if they're driving.
But it's already, it's okay, so where is this information going to go?
And as I told Senator Menendez, to the Secretary of State.
So if it's already, we're already doing this? Is that what you're trying to tell me?
Yes.
Okay, so if we're already doing this, then what's the amendment for?
The amendment is to make it clearer and clean up some previous language that the driver is to be notified that if they drive, they need to fill out a form.
The driver is to notify, or is to be
The
notified?
driver is to be notified by the election workers.
The driver is to be notified.
The election workers, let me restate it. The election worker must notify the driver that they need to fill out the form. But they already are required to fill out the form.
So all you're saying is whoever's running that polling place needs to inform the driver that they need to fill out the form that the election worker, whoever's running that location, is going to present to them.
That's correct.
That's correct? Is that what I'm saying?
That's
so when the person shows up that one time, or are they going to have to fill out that form are you saying in this amendment they're going to have to fill out that form every trip they make? Which is it?
Yes, they will fill it out. Every time they drive, they would fill out the form for each group of people.
This bill is sounding more like suppression than protection. No comment?
Well, I would disagree, sir. This bill is about making sure that curbside voting is accessed by people who need curbside voting.
Say that again? I'm sorry, say that again?
This bill is to ensure that people who legitimately need curbside voting have access to the curbside voting.
How does this amendment help do that?
This helps in situations where there's a driver. It clarifies previous law.
Yeah. Once again, you know what this amendment's going to do in my community? It's going to suppress the amount of drivers that we have or somebody driving. That's what it's going to do. It's going to prevent us from getting drivers. Thank you, Mr. President, members.
Senator Johnson, for what purpose?
Questions of the author of the bill and of the amendment, most particularly the amendment.
Senator Paxton, do you yield?
I do.
Senator Paxton, I was looking at this amendment here, this stricken language in brackets. I'll read it as if that language is not stricken. If the person indicates that the person, and this is the person driving people to the polls, if the person indicates that the person has assisted, I'm sorry, it's stricken. If a person who simultaneously assists 7 or more voters under this section by providing voters with transportation, et cetera, that was applicable to election day voting only, right? Previously. And so this amendment, I'll keep going, is not just doing the things that have already been discussed here. It does something else. It says that anybody who, maybe they don't have a minivan driving 7 people to the polls on election day, which, by the way, is a very noble thing to do, and they shouldn't be harassed for it. But this would be, if I give someone a ride on a motorcycle on Monday and another one on Tuesday and Wednesday, and I give rides to 7 people on 7 days during early voting, I got to fill out this same stuff, right? Under this amendment.
That's correct.
So what business does the state have in seeing whether or not I'm helping my friends do their civic duty of voting? Is that not like the scariest form of big government of the last hour? Because there's been a lot this session, actually, but certainly of the last day. What business does the state have in me? How do you justify this amendment?
Well, Senator Johnson, unfortunately, there are situations, and we've got these on record, people have been prosecuted for this, where there are vote harvesting initiatives that have folks that are hired to drive lots and lots of people. So it would be very different than what you're talking about, you driving your friend, and driving your other friend, driving your aunt, your uncle.
My 7 friends on 7 days.
7 friends, sure.
And if I just feel that it's my civic duty to get people to the polls to vote, my Republican friends, my Democratic friends,
I apologize, Senator Johnson. Could you repeat the question?
I feel like it's my civic duty, perhaps, or somebody might feel that it's their civic duty to bring as many people that they know, Republican or Democrat, to the polls to participate in our democratic process. And this amendment takes it another chilling step towards us being surveilled for exercising our civic rights and our civic duty. I recognize that there may be people who are motivated to mess with elections. I've never heard of any in my district in 6 years in office, but I guess it's theoretically possible. But is it worth the price of scaring people out of participating in our democracy because we think somebody might somehow be cheating despite all the elaborate means that we've put into place to stop voter fraud? Are we really worried that somebody's driving to the polls and thereby undermining the integrity of our elections?
Well, believe it or not, Senator Johnson, that has happened. This is on this.
It's been alleged.
And this is 7 or more. So you're not filling out a form for the first person, the second person, the third person, the fourth person, the fifth person, the sixth person.
So you
it's
said
when
that
you get to the 7th.
It's one
person.
form. I got it. So are you saying, I want to get the facts straight, that someone has been convicted of driving too many people to the polls?
There have been situations, and you know what, I can't answer your question about a conviction, Senator Johnson, but I do know of situations that we've all heard about. We've seen them in the newspaper.
Oh, I've heard stuff in the newspaper, but I'm not aware of anything actually happening.
There are folks that are involved in taking large groups of people.
Okay, I appreciate the clarification there. I don't think this is helpful in any way. Thank you.
Thank you, Senator Johnson.
Senator Campbell, for what purpose?
Just to ask a question of the author, the amendment.
Senator Paxton, do you yield?
I do.
I just wanted to ask, so if they have brought in 7 or more voters, and so they fill out their information on a card, what again, and I'm sorry if I missed it, what happens with that card?
It goes to the Secretary of State's office.
And if they, let's say they brought a van, are they able, that brings 7 at a time, just for the sake of a number, are they able to bring another van of 7?
They would just need to fill out another card.
Okay,
If they had
and that may have been
if they had a van with 6 people, they wouldn't have to fill out a card. But with this, if it had 7 people, and the 7th person they assist, they would need to.
Okay.
And then that would go to the Secretary of
And
State.
does somebody run through those cards at the Secretary of State's office to see?
The Secretary of State has rulemaking authority on how the cards will be handled.
Okay, I'm just trying to follow through what the Secretary of State's going to do with the cards and what follow through there is on the cards. So,
I believe they're just stored for documentation if needed.
do we ever go back and compare those names?
That would be a
that are
question for
stored
the
on the-
Secretary of State if they go back and compare those.
Okay.
Senator.
Thank you, Senator Paxton.
Thank you.
Senator Cook, for what purpose?
That's the question of the author of the amendment.
Senator Paxton, do you yield?
I do.
Thank you, Senator. Thank you, Mr. President. Okay, so I'm just trying to understand too, and I wasn't here when some of the laws in 2021 that I know you're reconciling with, and I know the list of stakeholders that you worked with on this amendment, so I really appreciate that. I think it's the getting rid of the word simultaneously that it seems like people are asking about. I have certainly driven at least 7 people to the polls. Let me just start by saying I wish that we all could walk and bike to the polls more easily instead of all having to drive, and the conversation always being about driving. But so I've certainly done that. So yeah, so I guess it's just if you're driving it's not like it's for any purpose, right? So if I pile 5 people in my minivan and we all go vote together, then that's up to 5.
Well, this is about curbside voting.
Okay,
So just,
specifically for curbside.
you know, however many people, you're not going to park in the curb on the curbside voting because these are just regular people that don't need assistance. This is specifically for people that need curbside assistance.
Okay, all right. So if church volunteers.
Yes, and that's why this was, again, brought to us by the Secretary of State's office in consultation with Texans for Disabilities and also the author, Chairman Guillen.
Does this apply to like Metro drivers?
No. Okay. That's something that will be taken under rulemaking by the Secretary of State's office, the Uber drivers and that sort of thing.
Okay, and
drivers.
so would commercial drivers like rideshare drivers and that sort of thing,
Yes.
The intent is to not capture those folks?
We're going to let the Secretary of State kind of decide how to do that because that's people who have been hired, right, by the voter.
And I guess, because it seemed like in the original, I think it was 2021, I'm so sorry, again, wasn't here, the simultaneously, it was trying to stop people from like gathering huge groups of folks, right, and getting them to the polls. And this is going to this is going to capture just somebody going one at a time. Okay, all right, thank you.
Thank you.
Senator Menendez, for what purpose?
Clarification, question of the author, Mr. President.
Senator Paxton, do you yield?
Do.
Senator Paxton, as I read the amendment and I read the bill, my concern is when you get on page 2, on line 27, let's start 22. Secretary of State shall prescribe the forms and process required by this section and adopt the rules necessary to implement this section. A person commits an offense if the person intentionally fails to complete the form required by subsection F. So that form is the one that higher up in the bill, it says the election officer presents that form to the driver. Is that correct? Is that how it works?
I'm looking for F myself there, sir. Yes, the form provided by the election officer.
Okay. So providing the voters with transportation, the person must complete and sign a form provided by the election officer that contains the person's. So your bill says that if the person intentionally fails to complete this form, that they've now had an offense that is a Class A misdemeanor.
So I read that to say they refuse to do the form.
Okay.
Do you read it that way, sir?
I'm concerned that the driver is not responsible for the form. Someone else has to hand them the form. So they're going to be reliant on that election officer handing them this form. Could there be an accusation later that, well, you didn't fill out the form and I know you've been a driver? A lot of campaigns volunteer to have rides for churches, for senior citizens, nutrition centers. This happens a lot in poorer communities where our seniors go and have their meals, get together, and many of them are handicapped, disabled, and have walkers, and sometimes you rent a minivan or rent a van, and 5 or 6 or 7 may end up at the same time getting in the van. And so my concern is that a volunteer, someone who's volunteering on a campaign, or a young person, inadvertently could possibly get convicted of a Class A misdemeanor. And you know, in Texas, I mean, I'm sure you're aware, but I want all the members to know a Class A misdemeanor is the most serious type of misdemeanor, punished up to, like we said, up to a year in jail and a fine of $4,000. I mean, examples of Class A misdemeanors are a second offense DWI, assault causing bodily injury, burglary of a motor vehicle, theft of property between $750 and $2,000, carrying a weapon unlawfully, possession of controlled substances, violation of a protective order, resisting arrest, public lewdness, and evading arrest. It seems that a Class A misdemeanor is, to me, for something that someone's driving people to vote and didn't fill out a form, is way over the top.
Are you concerned about someone who didn't fill out? Could you go back to why they didn't fill out the form? This is specifically around the issue of they refused to fill out the form as I read the bill.
So that's
and I guess I would say that I think the severity of the penalty is in equal weight to the sacredness of the right to vote and interfering with that. So I think that would be the reason for that.
But I think in your bill you cover that by, you say that if the poll site has 4 election workers, that 2 of them go out to make sure that there is no undue influence, that the driver is sitting in the driver's seat and not interfering with, because they bring the little laptop machine to the person, it has the little guards, and so no one can see which name the person is punching with the pencil eraser or whatever. So I don't see where the undue influence would be. My concern is that because some person who might be a volunteer drove people to the polls, they might be exposing themselves up to a year in jail and $4,000 fine. Now, the other thing is they don't control the form. That form has to be handed to them.
That's correct.
And what if the election officer runs out of forms, forgot to bring the form? What if they didn't bring the form and someone turns them in?
Well, I certainly think if someone is not given a form, they can't be accused of refusing. And so I think, that's, again, one of the things that we've authorized the Secretary of State in rulemaking is to deal with the minutia of this and the specifics of the implementation that might come up. And I'm sure as time goes on, a lot of the ways we find out about some of the rules we need to make are because of actual situations that happen. That's the genesis of the bill to start with.
All right, I appreciate it. I'm going to present an amendment to reduce the penalty because I just think the penalty is a little too high for that. But thank you for answering my question.
Thank you, sir.
Questions on the adoption of Senator Miles? For what purpose?
Just point of clarification.
Senator
One
Paxton,
simple point of
do you yield?
clarification.
I do.
Senator Paxton, I just want a point of clarification because I could have misread this, and I just want to hear it from your voice. This amendment, the Class A misdemeanor would be on the election judge for not providing the driver. No?
No.
So this amendment, the penalty would be on the driver.
Correct.
Not the election judge.
Correct.
So what if the election judge doesn't give the driver? What if Deacon Jones from the church pulls up driving a van for pastor and the election judge doesn't come out and give this to Deacon Jones, the driver? Deacon Jones doesn't know, he's just driving because pastor tells him. Who gets the citation here?
Well, I think in a case like that, Senator Miles, my view would be that you can't really be accused of refusing to sign something that wasn't offered to you.
So the violation would be on who?
There wouldn't, there's nothing that has happened there that would create a violation.
Well, the driver didn't fill out any
That's right.
paperwork.
He didn't refuse.
He did not. So
yes,
he didn't.
He didn't refuse because he wasn't offered.
Oh. Okay. Thank you.
Thank you.
The question is on the adoption of floor amendment number 1. Is there objection? There is objection. Secretary will call the roll.
I anticipate.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook, Creighton, Eckhart, Flores, Gutierrez, Hagenboo, Hall, Hancock, Hinojosa, Huffman, Hughes, Johnson, King, Goldcourse, Menendez, Middleton, Miles, Nichols, Parker, Paxton, Perry, Schwertner, Sparks, West, Zaffarini. On the amendment. Okay.
There being 19 ayes and 12 nays, amendment's adopted. Senator Paxton, you recognize for following amendment. Secretary, read the amendment.
Floor amendment number 2 by Zaffarini.
Senator Zaffarini, recognized.
Thank you, Mr. President. Mr. President, members, voters who accompany persons needing assistance may not be able to leave them alone in the vehicle, creating a practical barrier to casting their own ballots. This amendment would allow a voter who is escorting a person who is eligible for curbside assistance to request and to receive his or her own ballot at the polling place entrance or curbside. Mr. President, I move adoption, and I believe it's acceptable to the author.
Chair recognizes Senator Paxton on the amendment.
Thank you, Mr. President, and thank you, Senator Zaffarini, for this very agreeable amendment, and it is acceptable to the author.
Questions on the adoption of floor amendment number 2 is acceptable to the author. Is there any objection? Hearing none, amendment's adopted.
Thank you.
Following amendment, Secretary read the amendment.
Floor amendment number 3 by Menendez.
Senator Menendez, you're recognized.
Thank you, Mr. President. Members, if you just listen for just a second, you got to remember this legislation is trying to create a Class A misdemeanor, which is punishable up to 1 year in jail and a fine of $4,000, or both jail time and a fine. Class A misdemeanors, burglary of vehicle, carrying a gun without a permit, are examples. What I've done here, I looked at when someone were to park in a handicapped space, and this fine that you see here, you have a fine of no less than $550 or more than, not less than $550, but no more than $800, and 10 hours of community service. That's more than a Class C, punishable by a fine of up to $500. So it's more than a Class C misdemeanor, but it's not going to give any volunteer or election worker any jail time. Because I don't think any of you want to, I think everybody here wants to encourage people to vote. We want to help our senior citizens who sometimes need rides to vote, but we don't want to create an offense because someone volunteered to be a driver, didn't fill out a form, and now they're going to spend up to a year in jail or spend $4,000. I really think that for many of us here who are going to, okay, I will try. I'm not sure if you know what my note says here.
I do not.
My note says that if I can get folks to help you vote for this bill, they'll take the amendment. I just think it's a common sense amendment. I agree with you. I agree with you, Senator Paxton, that we need to make sure that people driving people to vote should not be telling them how to vote, 100%. But we also shouldn't be making criminals of people who are trying to just help people out to get to a vote, to the polls. And so I really think that Class A misdemeanor is way too big a fine. So that I came up with this. I think this is a serious. $550 is a lot of money. 10 hours of community service might even be more money. But I think this is something that would make the bill a little better. And, you know, I mean, I don't like the registry part of the bill because I don't think that makes any sense in terms of why do you have to have the names of people. So I present this amendment as a common sense amendment to a bill that has a place, but I think it goes a little too far. Thank you.
Senator Paxton, recognized.
Thank you, Mr. President, and I appreciate the spirit of this. And Senator Menendez, Class A misdemeanor is what we use across the board in election law for offenses, and so respectfully, I will oppose the amendment.
Questions on the adoption of floor amendment number 3? It is not acceptable to the author. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook, Creighton, Eckhart, Flores, Gutierrez, Hagenbu, Hall, Hancock, Hinojosa of Nueces, Hinojosa of Hidalgo, Huffman, Hughes, Johnson, King, Colcourse, Menendez, Middleton, Miles, Nichols, Parker, Paxton, Perry, Schwertner, Sparks, West, Zaffarini.
There being 13 ayes and 18 nays, the amendment fails. Senator Paxton, you recognized for a motion.
Thank you, Mr. President. I move passage to third reading.
Senator Paxton moves passage to third reading. There is objection. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook, Creighton, Edwards.
20 ayes, 11 nays. Bill is passed to third reading and will hold there.
Thank you, Mr. President. Thank you, members.
Senator Miles, for what purpose?
President, I want to make a motion that we have all exchanges that occurred on the suspension and the exchange that happened during the amendment process be reduced to write and placed in the journal, please.
Is there any objection to the motion? Hearing none, so adopted. Senator Perry. Senator Perry, you're recognized for a motion to suspend the regular order of business on House Bill 3000.
Thank you, Mr. President. Members, House Bill 3000, Rural EMS Grant Programs. Rural counties continually face hardships when trying to purchase large items, specifically an ambulance. This particular program and bill will set up a grant program in which they will have access to those that meet rural ambulance to purchase ambulance, those rural counties. With that, I move to suspend the regular order of business on HB 3000.
Senator Perry moves suspension of the regular order of business on House Bill 3000. Is there objection? Hearing none, the rules are suspended. Chair lays out on second reading House Bill 3000. The Secretary will read the caption.
House Bill 3000, relating to a grant program to provide financial assistance to qualified ambulance service providers in certain rural counties.
Following amendment, the Secretary read the amendment.
Floor Amendment Number 1 by Perry.
Senator Perry, you're recognized.
Floor Amendment number 1 is comptroller language that they were needing to make sure they knew how to administer the grant program. With that, I move adoption.
Questions on the adoption of floor amendment number 1? Is there any objection? Hearing none, the amendment is adopted. Senator Perry, you're recognized for a motion.
Move passage to third reading.
Senator Perry moves passage to third reading. Is there objection? Hearing none, the bill is passed to third reading. Senator Perry, you're recognized for a motion to suspend the constitutional 3-day rule.
Move to suspend the constitutional 3-day rule.
Senator Perry moves suspension of the 3-day rule. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco.
31 ayes, 0 nays. Rule is suspended. Chair lays out on third reading. Final passage, House Bill 3000. The Secretary will read the caption.
Move
House Bill
final.
3000, relating to a grant program to provide financial assistance to qualified ambulance service providers in certain rural counties.
Senator Perry, you're recognized for a
Move
motion.
final passage.
Senator Perry moves final passage, House Bill 3000. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco.
31 ayes, 0 nays. The bill is finally passed.
Thank you.
Senator Johnson, you're recognized for a motion to suspend the regular order of business on committee substitute House Bill 5616.
Thank you, members. Texas is the only state in the nation that has 3 presidential libraries. To honor and recognize the presidencies of Lyndon Baines Johnson, George H.W. Bush, and George W. Bush, House Bill 5616 directs the Texas Historical Commission to establish the Texas Presidential Library Promotion Program. The program aims to support statewide tourism and public education by developing mobile exhibits that will travel to communities across the state. Timing is significant, members, as the United States is now approaching its 250th anniversary in the year 2026. I move to suspend the regular order of business on House Bill 5616.
Senator Johnson moves suspension of the regular order of business on committee substitute for House Bill 5616. Is there objection? Hearing none, there is objection. Secretary, call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook.
26 ayes, 5 nays. Rules suspended. Chair lays out on second reading. Committee substitute for House Bill 5616. The Secretary will read the caption.
Committee substitute House Bill 5616, relating to the Texas Presidential Library Promotion Program and funding for the program.
Following amendment, Secretary read the amendment.
Floor Amendment Number 1 by Johnson.
Senator Johnson, you're recognized.
The original version of the bill provided funding for more than just the mobile libraries. It provided some funding for the permanent exhibits. This removes the permanent exhibits from the whole program, and it's now just for the mobile portion of the traveling exhibits for the libraries.
Questions on the adoption for amendment number 1? Is any objection? Hearing none, the amendment's adopted. Senator Johnson, you recognize for a motion.
I move passage to third reading.
Senator Johnson moves passage to third reading. There is objection. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell.
26 ayes, 5 nays. Bill is passed to third reading. Senator Johnson, you recognize for a motion to suspend the constitutional 3-day rule.
I move to suspend the constitutional 3-day rule.
Senator Johnson moves suspension of the 3-day rule. The Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell.
26 ayes and 5 nays. Rule is suspended. Chair lays out on third reading. Final passage. Committee substitute House Bill 5616. The Secretary will read the caption.
Committee substitute House Bill 5616 relating to the Texas Presidential Library Promotion Program.
Senator Johnson, you recognize for a motion.
I move final passage of the committee substitute to House Bill 5616.
Senator Johnson moves final passage. Committee substitute for House Bill 5616. The Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook, Creighton.
26 ayes and 5 nays. Bill is finally passed.
Thank you, Mr. President.
Senator Hughes, you're recognized for a motion to suspend the regular order of business on committee substitute to House Bill 4211.
Thank you, Mr. President. I move to suspend the regular order of business to take up and consider at this time House Bill 4211. Senators, this is about property rights and making sure that investors and residents in non-traditional developments have consumer protections and have their full rights, and that anti-discrimination laws are not being skirted. It addresses a troubling scheme where developers are charging potential applicants $80,000 just for the possibility of maybe qualifying as an investor. No guarantee of ownership, limits on the right to transfer, and again, questions about whether people are being treated fairly. This would clarify this, make sure that the sunshine is shining and the laws are being followed, and I move suspension.
Senator Hughes moves suspension of the regular order of business on committee substitute for House Bill 4211. Is there objection? Hearing none, the rules are suspended. Chair lays out on second reading committee substitute for House Bill 4211. The Secretary will read the caption.
Committee substitute House Bill 4211 relating to certain residential property interests controlled by certain entities.
Senator Hughes, you're recognized for a motion.
I move passage to third reading.
Senator Hughes moves passage to third reading. Is there objection? Hearing none, the bill is passed to third reading. Senator Hughes, you're recognized for a motion to suspend the constitutional three-day rule.
That's my motion.
Senator Hughes moves suspension of the three-day rule. The secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
30 ayes and 1 nay. Rule is suspended. Chair lays out on third reading. Final passage. Committee substitute House Bill 4211. The secretary will read the caption.
Committee substitute House Bill 4211 relating to certain residential property interests controlled by certain entities.
Senator Hughes, you're recognized for a motion.
Move final passage.
Senator Hughes moves final passage. Committee substitute for House Bill 4211. The secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
30 ayes and 1 nay. Bill is finally passed.
Thank you, Mr. President. Thank you, Senators.
Mr. Doorkeeper,
Mr. President, there's a message from the House.
admit the messenger.
Mr. President, I'm directed.
Thank you very much.
Senator Campbell, you're recognized on committee substitute for House Bill 1178, suspend the regular order of business.
Thank you, Mr. President. This bill grants a one-year teaching certificate for credentialed educators and a 3-year certificate for military spouses moving into the state, allowing immediate classroom placement, yet giving them time to get their Texas teaching certificate. And with that, Mr. President, I move suspension of the regular order of business.
Any objection? Hearing none, rule suspended. Chair lays down second reading. Committee substitute for House Bill 1178. And you're harassing us again up here. Every time I'm here, you're here. Every time. Every time. Secretary will read the caption.
Committee substitute House Bill 1178 relating to the creation of a temporary educator certificate for educators certified by other states.
You recognize passage to third reading.
So moved.
Any objection? Hearing none, bill passes to third reading and recognize suspend the constitutional 3-day rule.
So moved.
Secretary will call the roll.
Alvarado, Bencourt.
31 ayes, no nays. Rule suspended. Chair lays out third reading. Final passage. Committee substitute for House Bill 1178. Secretary, read the
So
caption.
moved.
Committee substitute House Bill 1178 relating to the creation of a temporary educator certificate for
You
educators.
recognize on final.
So moved.
Secretary will call the roll.
Alvarado, Bencourt.
31 ayes, no nays. That was fast. Thank
Thank you,
very
Mr.
much.
President. Thank you, members.
You worked all year on that bill and it took 30 seconds.
I know.
Senator Creighton, you're recognized on committee substitute for House Bill 2243.
Thank you, Mr. President. House Bill 2243 by Representative Oliverson responds to concerns addressed in the Texas Commission on Teacher Job Satisfaction and Retention. The commission will conduct a comprehensive review of the education code specifically aimed at reducing overlapping mandates and outdated regulations. This legislation directs the commission to examine key areas such as discipline policies, administrative requirements, and federal compliance mandates, and funding structures to identify what can be streamlined or eliminated. Without this review, we risk making piecemeal changes in the 90th legislative session and beyond that never really address the root of certain problems. By focusing on teacher job satisfaction, this legislation aims to retain our top teaching talent while removing unnecessary burdens that take time away from students. Mr. President, I move suspension of the regular order of business to take up and consider House Bill 2243.
Secretary will call the roll.
Alvarado, Bencourt,
20
Bourgeois.
ayes, 11 nays. The rule is suspended. Chair lays out on second reading. Committee substitute for House Bill 2243. Secretary, read the caption.
Committee substitute House Bill 2243 relating to the creation of the Texas Commission on Teacher Job Satisfaction and Retention.
You recognize passage to third reading.
Thank you, Mr. President. Move passage to third reading for committee substitute for House Bill 2243.
Secretary will call the roll.
Alvarado, Bencourt, Bourgeois, Blanco.
20 ayes, 11 nays. The bill passed to third reading, and you need to find a few friends or hold there.
Thank you, Mr. President.
You'd have to find 5 friends.
Senator Huffman, you recognize, suspend the regular order of business committee, substitute for House Bill 42.
Thank you, Mr. President and members. At this time, I move to suspend the regular order of business, take up and consider the committee substitute, House Bill 42. Members, the Higher Education Fund, also known as HEAF, is an annual GR appropriation dedicated by the Texas Constitution to support capital and infrastructure needs at institutions of higher education that are ineligible for available university fund support. HEAF is used to support ongoing maintenance, construction, acquisition of capital equipment, and deferred maintenance. In total, 31 institutions receive support from this fund. Unlike other funding sources, the Texas Constitution only allows the legislature to increase the HEAF appropriation once every 10 years. So the last time the funding level was increased was in 2015. The committee substitute to House Bill 42 provides funding allocations for the institutions, incorporating a 50% increase to the fund. This increase is in line with historical precedent for previous HEAF increases and totals $393.75 million in new funding to our institutions for the biennium. This would bring the biennial HEAF appropriation to $1.18 billion, a major commitment on the part of the state to help our institutions with facility cost and inflation. The committee substitute incorporates this new funding while adjusting institutional distributions to account for facility complexity, condition, and space deficits as determined by the Higher Education Coordinating Board. I move to suspend the regular order of business.
Any objection? Hearing none. Rules are. Senator Hughes, you're in the way. How many times have you tripped our wonderful secretary? Yes, not the right time to dance. Committee substitute for House Bill 42 on second reading. Secretary, read the caption.
Committee substitute House Bill 42 relating to the amount and allocation of the annual constitutional appropriation to certain agencies.
Carol, when you come by here, can you grab him and just take him with you? Go. She has work to do. No, she has work to do. Not. You recognize on passage third reading.
I move passage to third reading.
Any objection? Hearing none. Bill passed the third reading. You're recognized by the constitutional 3-day rule.
So moved.
Secretary will call the roll.
Alvarado, Betancourt, Bergman.
30 ayes and 1 nay. What can I tell you? The guy standing up here.
Did he vote nay?
Oh, he just made it unanimous. That's why you were up here to check. Yeah, sure. Okay. Third reading, final passage, committee substitute for House Bill 42. Secretary, read the caption. Secretary, read the caption on third reading.
Committee substitute House Bill 42 relating to the amount and allocation of the annual constitutional appropriation to certain agencies.
You recognize on final passage.
I move final passage of the committee substitute to House Bill 42.
Secretary will call the roll.
Alvarado, Betancourt, Bergman.
31 ayes, no nays. The bill's finally passed. Thank you.
Thank you.
Is this bill dealing with math teachers, Brandon? Carol, will you help him? Oh, no. Okay, there you go. See what happens. You're there? That was end of the session pity. That's what that was. Senator Creighton, somehow or another, you got your votes for suspension. Committee substitute for House Bill 2243. Secretary will call the roll.
Alvarado, Betancourt, Birdwell.
25 ayes, 6 nays. The rule is suspended. Chair now lays out Committee substitute for House Bill 2243. Third reading and final passage. Secretary, read the caption.
Committee substitute House Bill 2243 relating the creation of the Texas Commission on Teacher Job Satisfaction and Retention.
You're recognized on final.
Thank you, Mr. President. Move final passage. Committee substitute for House Bill 2243.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell.
21 ayes, 10 nays. The bill is finally passed. Thank you.
Thank you, Mr. President.
Mr. Doorkeeper,
Mr. President, there's a message from the House.
admit the messenger.
Mr. President, I'm directed by the House.
You're welcome. Come on down. It's like a game show. Thank you. Senator King, you're recognized on House Bill 2512 to suspend the regular order of business.
Thank you, Mr. President. This is a local bill for the city of Fort Worth, and it's needed due to a very unique situation in Fort Worth. Last session in 2023, the legislature passed SB 2038 by Senator Betancourt to allow residents and majority landholders to automatically remove their property from a municipality's ETJ by petition or election. Now, Fort Worth is in a unique situation because of active development agreements. Those are contracts negotiated between sophisticated parties. And in Fort Worth, they have these in place that date back to 2003. Because of those contracts, those development agreements, the city has invested hundreds of millions of public dollars in municipal infrastructure out into their ETJ. For example, in 2003, the city executed a development agreement with the property owner of Walsh Ranch in Fort Worth's western ETJ. Since executing that agreement, the city has spent over $250 million in municipal funds to construct water and sewer lines to serve Walsh Ranch and the general region. The city is concerned that this land, plus another 6,000 acres in adjacent development agreements, are at risk of being released from the city by the individual property owners and residents. SB 2038 includes a list of exceptions for land not eligible for release under the new statute. However, this list did not include land subject to active development agreements. And again, remember, in Fort Worth, these are contracts negotiated by very sophisticated parties long in advance of that legislation. The changes made by this bill would only apply to petitions filed or elections requested on or after the date this bill takes effect, and it would simply add Fort Worth's ETJ lines to the existing list of exceptions for land not eligible to be removed by petition. And with that, I move to suspend the regular order of business.
Senator Swerter, what purpose?
To ask questions of the author.
Do you yield?
Certainly.
Thank you, Mr. President. Senator King, first and foremost, I'm supportive of your piece of legislation and appreciate the concerns that you are trying to address for your constituency and for the developers and for the ratepayers that will have to be paying to service this $250 million of water and sewer infrastructure. That's a very big project in your district, and I want to make sure that your district gets taken care of regarding what you're trying to accomplish. And again, members, I think this is a very important bill to highlight some issues that have risen regarding aspects that we put forth as a state, and then the need to have exceptions. And that's what this bill is doing, right? It's allowing for an exception to a statewide policy.
Yes, it's an exception specifically for those properties within the current ETJ of the city of Fort Worth.
Right. And the policy, Senator, would you agree with me, is the policy that was put forth in Senate Bill 2038 from last session by Senator Betancourt of the ETF release or de-annexation policy that is now current state law, for which your bill is seeking an exception. Is that, do I got the premise right?
Yes, I think Fort Worth's unique situation is that it had these long-term development contracts between the city and these large property owners, and the city had, through very good planning, already executed a lot of infrastructure construction, and we're just trying to make sure that they still get the benefit of that instead of those public dollars being stranded.
Right, that they're not, the city is not stranded, the ratepayers are not paying for something that doesn't materialize. And in this case, it is the provision of water and wastewater to a specific area. And the concern is that area could de-annex or be released from the ETJ and do their own thing when it comes to water or wastewater.
Yeah, they've got very good relationships with the current owners, but developers change hands, companies change hands that are managing long-term development projects. These are large projects, very nice golf course developments, commercial properties. And the concern is that 5 or 10 years from now or next year, somebody from Wall Street buys out one of them and they remove themselves from the ETJ, and then those dollars are stranded.
And members, I want you to really key in on that. The concern is that a large developer, a large area could de-annex, causing significant issues associated with the taxpayers or ratepayers. And in fact, I think your bill analysis states that the land subject to the development agreement with the city may be released despite the significant investment in infrastructure made in connection with the development agreement, and that the land enclaves, the area around it, may be released, resulting in inefficient provision of municipal services. That's your bill, your sponsor's statement of the intent of this bill.
Yes, part of the unique situation with Fort Worth, they're one of the fastest growing cities in America. In fact, they just passed Austin in population.
Right. Senator, would you have any other ideas or thoughts about other concerns that might be brought by cities or neighbors or neighborhoods regarding an ETF area that is released besides this concern, water and wastewater?
Well, no, I'm just dealing with this bill at this time.
Right. How about emergency response? Do you think an area that's de-annexed and that is originally provided emergency services by a city, and then you're de-annexed it, and then the sheriffs, for instance, have to then pick up law enforcement for that de-annexed area in the ETJ. Would that be a concern maybe of those neighbors or that area?
Well, not in this specific circumstance. Again, I'm just trying to deal with those infrastructure investments that were made.
How about road maintenance in a de-annexed area? Do you think that could be a concern in a de-annexed area of an ETJ that was theoretically going to be taken care of by one municipal entity, but then a group or a small landowner in an ETJ de-annexed, and then that area is not part of that ETJ anymore, and road service is under the care and supervision and maintenance of the county?
And again, in this case, and I understand where you're going completely, but in this case, we were dealing with development contracts that had been entered into that said, we'll develop this land, City of Fort Worth will benefit from it, but you got to run infrastructure out to us first. And in fact, the largest of these contracts went back to 2003, so it's been a long-term concern about stranded
Yours is again, and I appreciate and support your bill, is water and wastewater regarding a very large project. But I've heard other issues raised with ETJ and de-annexation. And members, how about billboards? Would y'all like to see billboards in de-annexed areas of your ETJ that are within a municipal ETJ that were not allowed, but now are because an area of an ETJ has been de-annexed? Has that been brought to your attention in this area, Senator?
Not in this instance.
Right. And how about package plants? I know in particular you said water and wastewater, but if and this is a large development, but how about if it was a very small development and that developer decided to do a package plant right next to a neighborhood and to tie into the municipal wastewater line that was less than 1,000 feet away? Would that be a concern? That's not been a concern brought to you regarding this development, but wastewater is a concern in de-annexed areas, I would assume.
I understand your discussion. I'm trying to stay as close to my bill as I can.
I understand, Senator. What I'm getting at, members, and I hope you really key into this because every municipality is unique, and we on this floor, on certain bills this session regarding housing affordability, SB 15, SB 804, bracketed those areas only to municipalities less than 150,000 or counties less or over 150,000 or counties over 300,000 because of the concerns raised regarding planning, growth, and kind of integrity of the neighborhood and the municipality. That was not done with Senate Bill 2038 2 years ago. And de-annexation has been allowed to occur pretty rampantly in certain areas in fast-growing communities. And I have experienced in my district the concerns raised that I just articulated. Billboards, wastewater, emergency services, road maintenance, and the trouble of just trying to strategically plan for growth in a harmonized and reasonable manner. And so we're going to fix your issue today, and I'm going to support it. But I believe that the concerns raised over the last 2 years with de-annexation are very real and very pointed and need to be addressed, and have not, unfortunately, been addressed. We were very smart to put in the brackets in SB 15 and SB 804, which passed over in the House today, regarding, again, 150,000 for municipalities and 300,000 for counties. But we didn't do it in the past with Senate Bill 2038. And we need to address the concerns of growing cities and growing counties when it comes to wastewater, billboards, emergency services, package plants, and a whole host of other things. Who can actually de-annex? You can have a very small area de-annex in each. This is a very large area but you can have a very small area de-annex under Senate Bill 2038. So again, Senator, I'm supportive of your bill. I'm going to have an amendment that I'm going to bring up, and I've talked to many members on this floor. That amendment mirrors what was done already in Senate Bill 15, and Senate Bill 8, 140 from earlier this year regarding the bracketing. And we're going to have a discussion with that amendment if we could, sir. But I wanted to ask you why you were doing this, and I appreciate your efforts for your community and support your efforts to represent your community and address the problems that you have seen with de-annexation and ETF release. Thank you, Senator.
Senator Menendez, did you have your light on or off? You
Mr. President,
recognize?
I did, but when I heard that Senator Schwartner has an amendment, I said I would just wait for the amendment. So that's why I turned it off.
Members, the motion is on suspension of the regular order of business. Secretary, call the roll.
Alvarado, Betancourt, Birdwell, Blanco.
26 ayes and 5 nays. The rule is suspended. Chair lays out on second reading House Bill 2512. Secretary, read the caption.
House Bill 2512, relating to the release of certain areas from a municipality's extraterritorial jurisdiction by petition or election.
Members, the following amendment. Secretary will read the amendment.
Floor Amendment Number 1 by King.
You're recognized on your amendment, Senator.
Thank you, members. This just clarifies to make sure that the bill is very clear that it only applies to the city of Fort Worth, that it is truly a local bill.
Any objections? Hearing none, the amendment is adopted. Members, there is an amendment. Secretary, read the amendment.
Floor Amendment 2 by Schwartner.
Senator Schwartner, on your amendment.
Thank you, Mr. President. Members, I'd like to have your attention. Y'all look real closely at this language, because this is the language y'all saw and has now passed both chambers in Senate Bill 15 and Senate Bill 840. Senate Bill 15 by Senator Betancourt and Senate Bill 840 by Senator Hughes. And this bill would bracket in the, essentially retroactively bracket 2038, the bill from last session, when the policy of de-annexation and ETJs, what they call ETF release, and would mirror what we're doing with housing affordability. And I think this is the right policy for the state of Texas, because it allows independent decision-making at the local level while still addressing some concerns that are raised regarding municipal overreach. But these areas, again, of wastewater, water supply, law enforcement, road maintenance, signage maintenance, billboards in de-annexed areas are real issues that need to be addressed. And out of respect, and I think I have the votes on this floor to adopt this, but I'm not going to move forward with this because I respect you too much, Senator, to potentially have a point of order over on the House side. But what I'm asking is that those issues are addressed next session in a very proactive and thoughtful way. But I'd also like to suggest that this amendment, just like on SB 14 and SB 840, the brackets were put on this Senate floor. So this is not unusual to put in brackets and to make changes and to address concerns raised. If not, we're going to see more and more bills like your bill come to this House, this Capitol, when it comes to the provisions of de-annexation and ETF release and how they are not optimal for various portions of Texas. In this case, parts of Tarrant County. But I can give you list after list and map after map of concerns being raised, in particular in my district, in College Station and Georgetown, that are not been addressed this session, that I wish had been addressed this session, that need to be addressed next session. So with that, members, I am going to remove and take down floor amendment number 2.
Senator Schwartner, do you want to take any questions before you withdraw your amendment?
I'll be happy to take questions from anybody.
Yield to Senator Menendez. Will you yield, Senator?
I guess I'm the one asking questions.
I apologize.
Yeah.
Senator Schwartner,
yes.
will you take a question?
Thank you, Mr. President. Senator Schwartner, I was intrigued by the questions and answers and by your amendment.
it sounds like your concern is that if we allow this to run rampant, that these communities will have the people living in these communities will have very little protection. They won't have standardization. I think you brought up billboards, you brought up road construction standards, you brought up a lot of things that then when the city grows up around it, when the population, at some point, the rest of the taxpayers will have to inherit the problems that came around without having any kind of standards. Is that the concern?
It's a patchwork quilt of service territory regarding water, wastewater, emergency services. It creates holes throughout our cities and our ETJ areas. It's not thoughtful, it's not right, and it needs to be fixed.
I couldn't agree with you.
This amendment would fix that regarding exempting not just that portion of Fort Worth and not just the exemptions that were granted in the original bill. And there are a number of them, members, and I'll point you to the original language that's now law. But it would exempt, again, all counties less than 300,000 and all cities less than 150,000 that are fast growing, that have not a uniform, well-developed city apparatus, but actually have significant challenges with growth that need to be recognized, appreciated, and statutorily accommodated.
It sounds like we should be considering local control. Sounds like we should be considering the fact that our municipalities have the capacity to help our constituents at the closest level. And I think you bring up a lot of thoughtful points, but I just wanted to, it was an interesting exchange, and I wanted to ask you those questions because I share those concerns. And I appreciate your thoughtfulness to our friend Senator King to not put his bill in jeopardy. So thank you for answering my questions. Thank you, Mr. President.
Thank you.
Floor amendment number 2 then is withdrawn.
Thank you. Thank you, members, for your attention.
The following amendment, the Secretary will read the amendment.
Floor amendment number 3 by Bettencourt.
Chair recognizes Senator Bettencourt on the amendment.
Thank you, Mr. President. This amendment adds language as a technical cleanup of statutes for the ETJ, and identical language or nearly passed out of this chamber earlier this session, 27-4. I believe the amendment is acceptable to the sponsor and the House author.
Chair recognizes Senator King on the amendment.
It is acceptable.
Senator Schwartner, for what purpose?
Yes, I have questions of the amendment author, please.
Senator Bettencourt, do you yield?
Senator Bettencourt, this is a cleanup that is the cleanup bill for Senate Bill 2038 from last session, right?
Right.
And this amendment, members, was a bill. It was called the 2038 cleanup bill, at least in my office. That's what we termed it. Is that what you called it as well?
No, no, Senator, I did not.
Right. And so, again, it's okay to clean up 2038 sometimes, but not always. This does clean up some of the concerns you've raised regarding the provisions in statute currently that were passed under 2038, but there are more to do. Would you not agree?
Senator, I'd be happy to work with you in the interim.
Very good. I appreciate your answers.
Senator Eckhart, for what purpose?
To ask a procedural question, I don't believe this is the entire amendment.
On the back side.
There is nothing on the back.
Well, then it's time to get the back page out. That's right. It's okay. Yeah, that's right.
Members, it looks like we distributed the wrong amendment. Just a moment, we'll have the appropriate amendment and copies to everyone. Please hold.
Members, the correct amendment has been distributed. Are there any more questions of Senator Betancourt on floor amendment number 3? Right.
Is there objection to the adoption of the
Right. Members, Senator Betancourt moved adoption of floor amendment number 3. Is there objection? Hearing and seeing none, amendment is adopted. Okay. Senator King, you recognized for a motion?
Move passage to third reading.
Members, Senator King moves passage to third reading. There is objection. Secretary will call the roll.
Alvarado, Bettencourt,
There being
Birdwell.
26 ayes and 5 nays, the bill is passed third reading. Senator King, you recognize for a motion to suspend the constitutional 3-day rule.
So move.
Member Senator King moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Bettencourt,
There being
Birdwell.
26 ayes and 5 nays, the rule is suspended. Chair lays it on third reading and final passage. HB 2512, Secretary will read the caption.
HB 2512, relating to the release of certain areas from a municipality's extraterritorial jurisdiction by petition of election.
Senator King, you recognize for a motion.
Move final passage.
Member Senator King moves final passage. HB 2512. Secretary will call the roll.
Alvarado, Bettencourt,
There being
Birdwell.
26 ayes and 5 nays, the bill is finally passed. Congratulations, Senator King.
Thank you, Mr. President. Thank you, members, for the time.
Senator Middleton, you recognize for a motion to suspend the regular order of business, take up and consider House Bill 3372.
Thank you, Mr. President. Members, I move to suspend the Senate's regular order of business to take and consider House Bill 3372. House Bill 3372 is a targeted reform that places student outcomes at the forefront of public education policy by eliminating conflicts of interest. In recent years, there's been a troubling trend of moonlighting and backdoor consulting that has taken hold in some districts and is spreading across the state. This bill responds to a pattern where administrators leverage their official positions to promote or contract with educational consulting firms for personal gain. Crucially, members, teachers are explicitly not included in this bill, only administrators. House Bill 3372 ensures that the focus of public school leadership remains where it belongs, on students. It prohibits school district administrators from receiving any financial benefit from personal services provided to a business that seeks business with their school district. Additionally, administrators are barred from contracting with another school district, open enrollment charter school, or regional education service center unless permitted under the provisions of an amendment that I will offer, which, by the way, I've worked on with Senator Bettencourt, Senator West, and Senator Menendez, who voted no in committee on the bill. I just want to point that out. This bill puts student outcomes first and makes sure that our administrators are upholding the highest standards. With that, I move suspension.
Senator Hinojosa of Hidalgo, for what purpose?
Will the senator yield for a question?
Do you yield, Senator Middleton?
I do yield. Thank you.
You recognize Senator Hinojosa.
Thank you, Mr. President. Senator Middleton, I give just one or two questions, and that deals, when we're talking about administrators, we're talking about superintendents, principals, and people that actually have supervisory positions.
Right. It's those whose primary responsibility is not in classroom instruction.
And as you well know, it wouldn't apply, for example, for a nurse that may have to work in besides working in an elementary school or whatever school it is, working in another school, providing services to another elementary school, another high school, or another charter school.
I'll have an amendment on that. So yes, in the as-filed version, it could apply to that, but we've been working on a clarifying amendment to make sure that that could happen, but for certain conditions, which I'll lay out, transparency, essentially, that I'll lay out in an amendment.
I agree with your objective, with your goal of your bill. I don't think administrators ought to be working outside the school because many times they create LLC that comes back in contract with the school itself, where they are the consulting person for the LLC. They will get contracts and a clear conflict of interest. So
Right.
that I agree with. Just we need some clarification to make sure that we tighten the language to actually target administrators and not all of a sudden have such a wide net that we bring some of the educators that are not really in administrative positions.
Exactly, and that's what I intend to do with the amendment, where you're not in conflict with your own school district, right, and contracting to make money off your own school district that you're employed with. So that's what the amendment will clarify.
Thank you for answering my questions.
Senator Menendez, for what purpose?
Thank you, Mr. President. First of all, let me thank Senator Middleton.
Do yield, yes.
Do you yield, Senator Middleton? You recognize Senator
Yes,
Menendez?
I do yield. Thank you.
Thank you, Mr. President. First of all, let me thank Senator Middleton for his work on this. And Senator Middleton, I also agree with the premise of what you're trying to do, but I think as you remember, I can't even remember which late morning this was that we were in education around midnight discussing this bill, that we were just trying to keep people who have certain expertise. And if you remember, it was the Texas Association of, I think it was Special Education, Ms. Chevalier, who had talked about them. Sometimes they have the capacity to go consult in different things and go teach on specialty items. With your amendment, you're just going to keep it from applying people from being able to pretty much double dip in their district.
Right, it prevents double dipping, and then also if you're going to go, and this is the amendment for layout later, but if you're going to go provide those services for another district, there needs to be a heightened level of transparency, right? That the board needs to be aware and some other elements need to be satisfied.
Yeah, everybody needs to be aware, especially those who are paying you, who you have a contract with. They need to know that you're making, yeah, that makes all the sense in the world. Does your bill apply to charter school administrators as well, since they're public schools?
So in this bill, we prohibit administrators from contracting with outside, obviously, but it would apply to districts only, actually. So
it only applies to traditional ISD, not to public charter schools?
Right.
Well, would you be open to taking an amendment to including charter schools? Because you have you're trying to protect the taxpayers from having people, the administrators who are getting paid by the district, from actually making money off the district. It's a great policy. I don't know why we wouldn't want to apply it to the charter schools as well.
Right, I would be open to an amendment.
Great, yeah. I'll get it drafted. Thank you.
Yeah.
Senator Cook, for what purpose?
To ask the author a quick question.
Do you yield, Senator Middleton?
Do.
Thank
You
you.
recognize Senator Cook?
Thank you, Mr. President. Does it differentiate between, because I don't know, administrator, like superintendent versus a person who sits at a desk?
No.
Or is it anybody?
No, it basically, the only element here, the test, is that your contract responsibilities primarily include classroom instruction, and that's the exemption, right? So anyone that doesn't meet that would be in the bill.
Okay, so a gal sitting at the front desk could be captured by administrator?
Perhaps, yeah, if it's not primarily classroom instruction, yes.
Okay, thank you.
Yeah.
Why didn't you just tell me that?
Senator Middleton, you're recognized.
Thank you, Mr. President. I'm going to withdraw that motion so we can get that amendment drafted quickly.
Okay, thank you. Members, Senator Middleton pulls down his motion to suspend the regular order of business on House Bill 3372. Senator Schwarten, you're recognized for a motion to suspend the regular order of business, take up and consider committee substitute House Bill 14.
Thank you, Mr. President. I move suspension of the regular order of business, take and consider at this time the committee substitute to House Bill 14. Members, House Bill 14 seeks to advance the development of nuclear energy industries in Texas by supporting both generation facilities and supply chain infrastructure. This bill creates the Texas Advanced Nuclear Energy Office and the Texas Advanced Nuclear Development Fund with $350 million appropriated toward development and deployment activities this biennium. Specifically, House Bill 14 establishes 2 reimbursement grant programs, the first one targeting early project development, and the second one directed to docketed projects that have reached certain regulatory milestones. These grants would be selected and awarded by the Nuclear Energy Office, subject to the approval of the governor, lieutenant governor, and speaker through the LBB process. No more than 20% of the appropriated funds can be used for pre-construction grants. No more than 80% can be used for construction stage grants. The bill also establishes a framework for a completion bonus grant awarded to grid-connected reactors based on megawatt output to the ERCOT grid. As nuclear becomes an option for our state, future legislatures may use this program to incentivize generation projects. The bill creates the Texas Advanced Nuclear Energy Office within the Office of the Governor. Led by a director and with the support of a nuclear permitting coordinator, the Nuclear Energy Office would develop a strategic plan to support nuclear technologies and generation projects in Texas and grow a nuclear industry around high-skilled jobs, research, economic development, and energy security. Members, advancements in nuclear energy offer a promising opportunity to strengthen our electric grid with reliable, dispatchable generation while supporting the growth of this innovative industry in Texas. There will be 2 floor amendments. The first floor amendment is a clarifying and perfecting amendment, and the second amendment has places sunset date and expiration date of the statute. Mr. President, I move suspension of the regular order of business on House Bill 14.
Senator Menendez, for what purpose?
Questions of the author, Mr. President.
Do you yield, Senator Schwartner?
I yield.
You recognize Senator Menendez.
Thank you, Mr. President. Chairman Schwartner, I remember this bill in committee, and in committee we talked about the grant. And does the grant also apply to construction?
Yes, there is development and deployment are the 2 big categories, and construction would be under deployment.
And do we know how much the total of the grant is in the bill?
It's well, the total amount in the Texas budget this time is $350 million toward this endeavor. But the grants are awarded based upon, of course, the size of the project. No more than 80% can be used for construction stage grants, and of those grants, the grants have to be docketed projects that have reached certain regulatory milestones, with grants of up to $100 million or 50% of the cost, whichever is less. And as you know, Senator, the costs for nuclear projects are significant most of the time.
The grant would be no more than $12.5 million.
That's for the earlier stage development type grants.
I see. Would it not make a little more sense to maybe do a revolving loan so that they would pay them back and we could reinstate more money into the system and encourage more nuclear development?
Right. There's different ways to incentivize industry. Certainly last session with passage of the Texas Energy Fund that was, of course, ratified by the people of Texas. Those are primarily of the $10 billion in the TEF, $7.2 billion are low interest rate loans that will be paid back to the Treasury of Texas. But also in the TEF were completion-based bonuses that's actually grants.
Right.
In this endeavor, under the nuclear Texas Advanced Nuclear Energy Office and the Development Fund that they will administer, the monies in that fund will be grant money. It is not low interest rate loans.
And I think some of these are reimbursements, right? That's a reimbursement program? Because I'm trying to figure out.
Yes, it's reimbursement for monies expended toward those endeavors, development or deployment.
So they're at risk if they don't complete the things they say they're going to do.
They do have risk, yes, certainly.
They would not
and this
get
is
reimbursed.
a portion of their overall capital structure. So there is obviously an application, a vetting process, and final approval by the offices by the Lieutenant Governor, the Speaker, and of course the Governor, the Office of the Governor, which will be administering the Texas Nuclear Energy Office and the actual development fund grants. They, as you know, Senator, they do a lot of different grant programs, as we're well aware, including the emerging, the Enterprise Fund is probably the most notable.
Absolutely. No. And look, we've heard over and over how dramatically the demand for more energy, more electrons is in this state. I mean, you know, there's lots of different projections, some as much as doubling the current demand that we have now. So I am all for encouraging new generation. I just want to make sure that we are as vigilant and as cautious and as careful with the taxpayers' money as being stewards in their investment as we tend to be sometimes with other sources of generation. And so I'm aware that nuclear, once it's built, is very stable. But the problem is that during our committee hearing, when this bill first came up, we heard over and over that most of the generation was not really close to completion. And so that was my concern. And so I was just making sure that as we move forward, that we're agnostic in some senses as to the source of the energy, but looking for what can we do as a legislature to get more electrons on the grid as soon as possible. And so that's what I'm hoping.
I appreciate your comments very, very much. The idea is Texas should lead in this endeavor. There's been a change of leadership on a national basis with a re-emphasis on nuclear technology. The development of the technology appears to be proceeding at a rapid pace. Hopefully the approval process and the ability to get projects to a docketed / permitted phase to where they at least have shown a significant amount of data to the NRC and gone to that stage to get that permit, that we need to be commensurate and coordinating, and we need that electricity more than any other part of the United States. We actually use far more electricity, as you know, Senator, than California. We need to be developing, incentivizing, and helping all sorts of generation technologies to meet the demand in the future. And this is the thought process with this piece of legislation that we need in office. We need to show that we are helping out from a coordination standpoint, helping the locals and the states and the federal government in a coordinated fashion to help with the supply chain as well, and then also put our own state resources, our taxpayer dollars, toward projects both in the supply chain through a development and then a deployment grant program as well, that we are all in on nuclear energy and the industry that is coming forth.
Well, I know you're going to continue to be a leader in this process as it moves forward. I just hope that as we move forward, that we look at the potential for nuclear that has helped also with the potential for desal and using some of the waste for medical isotopes and other things. Some of the nuclear, this new version of the small reactors that seem to be ahead of the curve, seem to be much more efficient and cleaner. And I just hope that we focus on those that are a little bit more proven, better, newer technology, rather than waste hundreds of millions of dollars on old technology.
I agree with your comments, and thank you very much for your questions.
Thank you. Thank you very much.
Senator Perry, for what purpose?
Ask the author a question.
Do you yield, Senator Schwartner?
I yield.
You recognize Senator Perry.
The construction part of this deal, you said there'd be certain metrics, so that would be a federal permit for construction would be one of those, correct?
That is correct. They got to get a permit through the NRC, which sometimes takes 5-10 years before they're docketed, and then they get there's several permitting processes that occur.
There's
operational permit and construction permit.
And construction and operational, but at construction, they would be eligible for the construction piece of this, and that's 50%.
Or 100 million, whichever is less.
Whichever one's less, okay. And when is this thing going to be up and running and deployable as far as the actual grants availability? Is it?
The office has to be first, they have to pick a director, hire personnel. There is some cost associated with that, but I would expect this year.
This year, so potentially by the end of the year, we'd have this office stood up. Okay.
Yes, I don't know the specifics of how fast you can set up. This, of course, has to be signed into law and take effect, which effective date might be September. So
I think that's what I was looking at. I know it takes a little time once it's passed to roll through. I think we got a pool of eligible candidates to fill that role. They've been talking about this for a while, but I appreciate your work on it. I think it's the state's moving forward in the right direction. We got tons of gas, and we need to exploit that and hundreds of years of it, but we need another source of energy, just diversity of it, and actually kind of a little more flexibility where you put it when you need it. So I appreciate you.
Thank you. Thank you, Senator.
Members, Senator Schwartner moves suspension of the regular order of business on committee substitute House Bill 14. There is objection. Secretary will call the roll.
Alvarado, Bencourt, Bardwell.
There being 26 ayes and 5 nays, the rule is suspended. Chair lays that on second reading. Committee substitute House Bill 14. Secretary will read the caption.
Committee substitute House Bill 14 relating to support for the development of the nuclear energy industry.
Members, there is an amendment. Secretary will read the amendment.
Floor Amendment Number 1 by Schwartner.
Senator Schwartner on the amendment.
Thank you, members. This is a clarifying and perfecting amendment that does a number of things. First, it incorporates appropriate terminology and clarifies ambiguous terms. Second, it focuses the duties and responsibilities of the director and nuclear permitting coordinator. Third, it involves the legislature and the PUC in greater detail, ensuring the PUC participates in the regulatory review of nuclear projects, and the legislature receives and reviews the office's strategic plan. Fourth, the amendment updates the reimbursement grant provision to specify that grants go to expenses paid by eligible recipients only. And fifth, ensures project siting remains flexible and not a mandated location. And finally, it limits the completion bonus to interconnected and operational nuclear facilities in ERCOT. I move adoption of floor amendment number 1.
Any objection? Hearing none. Amendment passes. Following amendment, Secretary, read the amendment.
Floor Amendment Number 2 by Schwartner.
Senator Schwartner, on your amendment.
Thank you, Mr. President. Members, this amendment replaces the statute's expiration date with a sunset review in 2035, which is consistent with other offices and commissions under the governor's office. This reaffirms Texas's commitment to developing a nuclear industry by ensuring the continued existence of the nuclear office.
Any objection?
Move adoption.
Hearing none. Amendment is adopted. You're recognized for passage of third reading.
So moved, Mr. President.
Secretary will call the roll.
Alvarado, Bencourt, Birdwell.
26 ayes, 5 nays. The bill passed the third reading. You're recognized to amend the constitutional 3-day rule.
So moved, Mr. President.
Secretary will call the roll.
Alvarado, Bencourt, Birdwell.
26 ayes, 5 nays. Rule suspended. Chair lays out third reading and final passage. Committee substitute for House Bill 14. Secretary will read the caption.
Committee Substitute House Bill 14 relating to support for the development of the nuclear energy industry.
You're recognized on final.
Move final passage to Committee Substitute House Bill 14.
Secretary will call the roll.
Alvarado, Bencourt, Birdwell.
26 ayes, 5 nays. The bill is finally passed. Thank you.
Thank you, Mr. President. Thank you, members.
Senator Sparks, you're recognized on House Bill 3057? Suspend the regular order of business.
Thank you, Mr. President, and thank you, members. I move at this time to suspend the regular order of business in order to take up and consider House Bill 3057. CAR T-cell therapy is a treatment that uses a patient's own immune system to fight cancer. It begins by collecting the patient's blood to isolate their T-cells. Those T-cells are then re-engineered in a lab to recognize and destroy cancer cells and then infused back into the patient. However, some health plans require that patients stay near one of just a handful of hospitals accredited by the Foundation for the Accreditation of Cellular Therapy, or FACT. These facilities are located only in urban settings, creating a barrier to health care for rural Texans. In 2019, the Centers for Medicare and Medicaid Services determined that FACT accreditation is not required for patients treated in qualified CAR T-cell centers that follow strict FDA guidelines. House Bill 3057 would ensure that if a plan covers this treatment, then they must provide coverage at a qualified healthcare facility that meets FDA regulations. With that, Mr. President, I move suspension.
Any objection? Hearing none. Rules are suspended. Chair lays out in second reading House Bill 3057. Secretary, read the caption.
House Bill 3057 relating to health benefit plan coverage of antigen receptor T-cell therapy.
You recognize on passage to third reading.
Thank you, Mr. President. I move passage to third reading.
Any objection? Hearing none. Bill passes to the third reading. You recognize suspend the constitutional three-day rule. You're recognized to suspend the constitutional three-day rule.
I'm sorry. So moved, Mr. President.
Just dozed off there just for a moment. Secretary will call the roll.
Alvarado, Bencourt, Bordenave.
30 ayes and 1 nay. The rule is suspended. Chair lays out third reading and final passage. House Bill 3057. Secretary, read the caption.
House Bill 3057 relating to health benefit plan coverage for chimeric antigen receptor T-cell therapy.
You're recognized on final.
Thank you, Mr. President. I move final passage of House Bill 3057.
Secretary will call the roll.
Alvarado, Bencourt, Bordenave.
30 ayes and 1 nay. The bill is finally passed. Thank you.
Thank you, Mr. President. Thank you, members.
Senator Bettencourt. Senator Menendez, you recognize committee substitute for House Bill 1211, suspend the regular order of business.
Thank you, Mr. President. Members, I move to suspend the Senate's regular order of business, take up and consider at this time the committee substituted House Bill 1211 by Representative Lujan. We all recognize that our state is responsible for our foster youth and should work to ensure that they can achieve the same potential as their peers. In recognition of that responsibility, we've granted current and former foster youth in this state tuition exemptions from public colleges and universities. However, these prospective students can only access college through this pathway before their 25th birthday. The committee substitute House Bill 1211 by Representative Lujan increases the deadline for former foster youth to utilize the state college tuition waiver by 2 years from a student's 25th birthday to the 27th birthday. Today, approximately 3,000 foster youth use these waivers annually, creating opportunities for these Texans to obtain higher education and socioeconomic mobility. However, many more foster youth are not aware of this program, and even when eligible students are aware of this waiver program, they may not be in a position to be able to use it. Raising this age limit acknowledges these challenges and will allow for more Texans who are eligible for this waiver to utilize this when they are ready to do so, regardless of their age. And members, just as a note, if a foster youth is adopted, their ability to get free public higher ed has no age limit. And so really we should provide them parity, but in working with some folks that were concerned about costs, this is as good as we can do for now, and I move suspension of regular order of business.
Secretary will call the roll.
Alvarado, Bettencourt, Boardwell.
27 ayes, 4 nays, rules suspended. Chair lays out in second reading. Committee substitute for House Bill 1211. Secretary, read the caption.
Committee substitute House Bill 1211 relating to tuition and fee exemptions at public institutions of higher education for certain students.
You're recognized.
Thank you, Mr. President. I move passage third reading.
Secretary, any objection? Well, you've got 4 votes against. You'll have to call the roll.
Alvarado, Bettencourt, Boardwell.
27 ayes, 4 nays. The bill passed the third reading. You recognize suspend the constitutional 3-day rule.
So moved, Mr. President.
Those same 4 people are.
Yeah, sometimes,
Secretary, call the roll.
Alvarado, Bettencourt, Boardwell, Blanco.
27 ayes, 4 nays, rule suspended. Chair lays out third reading, final passage. Committee substitute for House Bill 1211. Secretary, read the caption.
Committee substitute House Bill 1211 relating to tuition and fee exemptions at public institutions of higher education for certain students.
You recognize on final.
Mr. President, I move final passage to third reading of committee substitute 1211.
Secretary, call the roll.
Alvarado, Bettencourt, Boardwell.
27 ayes and 4 nays. You talk a lot less to pass a bill than you talk when a bill's not passing. That was pretty fast.
Mr. President, I'm happy to answer any questions. If you want me to slow it down, I'll slow it down, whatever you want.
I just thought maybe you could get those other 4 votes if you'd have done something,
Yeah, if they'd come to me, I would have convinced them to vote for the bill. Thank you, Mr. President.
Thank you. Senator Middleton, we're starting all over with your bill, apparently.
We
You recognize
are.
suspend the regular order of business on House Bill 3372.
Thank you, Mr. President. Members, I move to suspend the Senate's regular order of business to consider House Bill 3372. And we have 2 amendments.
Did you lay it out before?
I did.
You did. You want to just give them a hint, just short, just a little bit?
Little hint here.
They're not remembering your bills like
House
you
Bill
are.
3372 ensures that we are making certain that our public school districts have administrators that are serving the district they work for first and don't have conflicts of interest that ultimately will compromise the educational integrity of the district they work for. And we're just making sure those conflicts are not compromising the public education of our students in Texas.
Sound like you're winding down. Secretary will call the roll.
Alvarado, Bettencourt, Cardwell.
24 ayes, 7 nays, the rules suspended. Chair lays out on third reading House Bill 3372.
House Bill 3372 relating to prohibiting certain personal services performed by school district administrators.
Members, there's an amendment. The Secretary will read the amendment.
Floor amendment number 1 by Middleton.
You're recognized.
Thank you, Mr. President. Members, worked with our Senate colleagues on this. This amendment reflects feedback from many members of the Education Committee and on the floor, and is a common sense adjustment to House Bill 3372. Under the amendment, administrators may only be compensated for outside services if a written contract is submitted to their district board and the board determines the work poses no conflict of interest, causes no harm, and is done entirely on personal time. And the contract is also subject to public disclosure under the Public Information Act. And we also wanted to make sure that it only covers administrators that are not at the trustee level, the superintendent level, or the assistant superintendent level, because those are the leaders of the district and they should not be working for other school districts or charters or education service centers. So work with our colleagues on that. Thank you all for your input on this amendment.
Senator Cook, you're recognized.
Thank you, Mr. President. I just wanted to ask a quick question just to make sure everybody at home knows what's going on and say thank you so much for working with me. I'm glad we get to close out the session. I feel like we should savor this a little bit. So I just want to make sure I'm reading it correctly. Once this amendment is added onto your bill, a superintendent is forbidden from making money working for a charter district, a different district, anything like that, correct?
Right. So they may not contract with another district, with a charter school, with an education service center, and it applies to the leaders. So the administrator includes trustee, member of board of managers, superintendent, or assistant superintendent.
And obviously there's no clawback or anything in this, but a current superintendent, deputy, board of managers, trustees, if they're currently making money from another educational entity, they will have to stop doing that.
When it goes into effect in September.
Beautiful. And this will not apply to the person sitting at a desk, a special ed consultant administrator. They can still go out and make extra money, but they just have to disclose it all.
Right. They may still contract, but they have to meet certain disclosure requirements, and the board of the trustees of the school district they work for has to be made aware of that. So there's a lot of transparency in it.
Awesome. Thank you so much. Thank you for this amendment and for the bill.
Thank you.
Senator Menendez, what purpose?
I just wondered if Senator Milton would consider a name for his amendment. I like this amendment very much.
Would you consider a name for this amendment?
What do you want to name it, Senator?
No double dipping amendment.
What? I'm sorry.
No double dipping.
No double dipping. I love it.
No double dipping on the taxpayer.
No double dipping on the that's a name. I think we got unanimous support for that here today on the floor.
Anti-double dipping.
Is there any objection? Except for ice cream, they're all with you. Senator Hinojosa, what purpose?
Well, Senator Middleton, you for a question.
I do yield.
This kumbaya moment with you.
Well, I do have some questions to ask and need some clarification. What type of amendment or what type of contracts is the school board supposed to okay and agree with?
Right. So this is regarding contracts for those that are exempt, which is the anyone below a level of superintendent, assistant superintendent, or someone that is board of manager. And it includes education businesses, right? So provide services for curriculum or administration to a school district, or any other type of financial benefit an administrator receives from services performed for another school district, open enrollment charter school, or regional education service center.
So could a principal enter into a contract and get the board to approve the contract?
That's correct. The board would have to approve it. It's not prohibited, but they would have to approve it.
Well, and that's part of the issue for me, and I like your bill, and that is we have situations in some school districts in South Texas where the board members are actually working with the principal, and they'll approve the contract to also benefit from bribes, benefit from taxpayers' money, to the point that 2 of them got indicted, and including the principal, an administrator. So while your amendment is good, it still leaves some loopholes because I think it should quite frankly completely prohibit and not allow any administrator, whether it's a principal, assistant principal, or any type of administrator, to be able to enter into this type of contracts, period. Because many times the board will just rubber stamp some of this approvals for principals, which I think is not for the good public policy.
And I totally agree with you. You know, we've been working with members on this amendment. Obviously, the as-filed version was stronger, but I will say that when they're looking at this contract, it requires the school board voting on this contract to approve it or disapprove it, that it will not harm the district, that the arrangement does not present a conflict of interest, and that the services performed by the administrator will be performed entirely on the administrator's personal time, right? So they have to certify that in this approval process, right? So I think that provides a lot of transparency that's not there right now, and it's a great step in the right direction.
I agree, it's just a step, but we may have to come back and look at this again, because the experience that I've had in dealing with some of these issues, that is very easily they're pretty easy to get around it. But thank you, Senator Middleton, for answering my questions.
Where were we?
I move
We're on
adoption.
Adoption of floor amendment number 1. Any objection? You know, it's only taken 5 months, but you finally have all the Democrats liking a bill of yours.
And not only that, making it stronger with the floor amendment. Yeah.
Following amendment, Secretary, read the amendment.
Floor amendment number 2 by Menendez.
Senator Menendez.
Thank you, Mr. Speaker. Mr. President. It's been a long night, long day. That's the first time I think I've done that one. But this amendment would also make this bill stronger by making sure that it would apply to charter school administrators, but because of the caption being as tight as your bill's caption is, I don't want to endanger your good legislation, your good policy, but I want to see if you believe, if we work together to make sure moving forward, hopefully if they're listening, they'll be careful not to do this. You know, if they're a superintendent, deputy superintendent, they shouldn't be looking for a job consulting somewhere else. Do you agree?
100% agree. I support this amendment, but you know, of course, I share your concern that it would expand the class and potentially compromise the bill.
I don't want to put a point of order on your bill, so at this time, I'll withdraw floor amendment number 2, Mr. President.
Thank you, Senator.
Thank you. The amendment is withdrawn. Senator Betancourt, what purpose? Yes, it helps if you have your microphone in front of you.
I was expecting the amendment to go on.
Okay. You can speak now.
Thank you, Mr. President. Senator Middleton, I just want to thank you because I know Senator Menendez, Senator West, and I had a long discussion I think at sometime at 1 a.m. or what time was it? I can't even remember.
It was about 12:15 to about 1:15 a.m.
Yeah, 12:15, 1:15 a.m. And I think the important thing is these amendments have made the bill a lot stronger and also recognized what you really wanted to do, which was make sure somebody wasn't double dipping, but also allow for people to have their own time to be able to do their own work. True?
That's right.
This is an example of how the Senate works. Senator Menendez, it's we might call the three of us the three sages or something to that effect, but I would appreciate you listening, and this may be one of your last bills that flies out of here. We finally, Mr. President, we finally got him trained. He got a 31-0 amendment. He's taking amendments, listening, and now he's doing something else. So Godspeed, my friend.
Thank you, Senator.
Thank you.
It was fun to work with you on this.
You are recognized on passage to third reading.
Thank you, Mr. President. Move passage to third reading.
Secretary will call the roll.
Alvarado, Bettencourt, Bardwell, Blanco.
28 ayes and 3 nays. Passage to third readings. You're recognized to suspend the constitutional 3-day rule.
So moved, President.
Secretary will call the roll.
Alvarado, Bettencourt, Bardwell, Blanco.
27 ayes and 4 nays. The constitutional rule is suspended. Chair now lays out third reading and final passage. House Bill 3372. Secretary will read the caption.
House Bill 3372, relating to prohibiting certain personal services performed by school district administrators.
You're recognized on final.
Move final passage.
Is this your last bill?
Got some more. There's some that may want it to be, but I don't think that it is.
It's a good bill.
Good bill.
With the no double dipping amendment. Secretary will call the roll.
Alvarado, Bettencourt, Bardwell, Blanco.
28 ayes, 3 nays. The bill's finally passed. Thank you.
Thank you, Mr. President. Yeah.
Senator Hagan, bill you recognize to suspend the regular order of business on House Bill 2407. Members, we need to have a little quiet and decorum on the floor.
Thank you, Mr. President. Members, HB 2407 is a bill I'm sponsoring with Representative Capriglione that pertains to the Texas sex offender registration system. Under current law, convicted sex offenders must register with law enforcement to help protect our communities and reduce the risk of repeat offenses. Unfortunately, there is a loophole in the current statute that allows some individuals to knowingly avoid these legal obligations while still not being sentenced according to the severity of the crime. House Bill 2407 strengthens the Texas sex offender registration system by correcting the statute to enhance the penalties for certain individuals who repeatedly fail to comply with the registration requirements. By amending Chapter 62 of the Code of Criminal Procedure to increase the criminal penalty for failing to comply with sex offender registration requirements, particularly in the cases involving repeat offenders or individuals who intentionally evade detection, it will allow courts to properly sentence offenders for the severity of their crimes. The bill also reinforces the seriousness of these registration laws, supports the efforts of law enforcement, and enhances public safety by ensuring greater accountability among offenders. I would like to clarify that HB 2407 does not apply retroactively, but only pertains to offenses committed after this bill is effective. With that, Mr. President, I move suspension of the normal order of business.
Any objection? Hearing none. Rules are suspended. Chair lays out second reading. House Bill 2407. Secretary, read the caption.
House Bill 2407 relating to increasing the criminal penalty for the failure of certain sex offenders to comply with sex offender registration requirements.
You're recognized on passage to third reading.
Thank you, Mr. President. Move passage to third reading.
Secretary, any objection? Hearing none. Bill passed to third reading. You're recognized to suspend the constitutional 3-day rule.
Thank you, Mr. President. So moved.
Secretary, call the roll.
Alvarado, Bettencourt.
31 ayes, no nays. Rule suspended. Chair lays out third reading and final passage. House Bill 2407. Secretary, read the caption.
House Bill 2407 relating to increasing the criminal penalty for the failure of certain sex offenders to comply with sex offender registration requirements.
You're recognized on final.
Thank you, Mr. President. Move final passage.
Secretary, call the roll.
Alvarado, Bettencourt.
31 ayes, no nays. The bill is finally passed.
Thank you, Mr. President. Thank you, members.
Senator Paxton, you're recognized to suspend the regular order of business and committee substitute for House Bill 4623.
Thank you, Mr. President. Thank you, members. I move to suspend the regular order of business to take up and consider House Bill 4623. Members, we have addressed the dark subject of child sexual abuse from many vantage points this session, and I'm thankful for that. One of the sad and perverse characteristic realities of this dark issue that we hear over and over again is that child sexual predators hunt children in their natural habitat. They embed themselves in the very institutions to which we entrust our children. Our churches, summer camps, youth organizations, daycares, and yes, our schools. I know that not a single person in this room has any tolerance for a child sex abuser who would don the trusted mantle of a teacher or a coach or a bus driver in order to create unfettered access to innocent children. Perhaps the only thing we might find more reprehensible would be school district personnel turning a blind eye to this evil, or worse yet, enabling such an atrocity. Some of you are thinking that surely this is exaggerated. Surely such things could not happen. But just past midnight, last Thursday night, very early Friday morning, House Bill 4623 was heard in the Senate Education Committee. And as we looked into the eyes of victims and survivors and the parents, it forced us to all make eye contact with something none of us wanted to see or was prepared to see. The dark and devastating truth that the unthinkable has and is happening to children in our schools. Not just cold and calculated sexual abuse of little children, but school districts literally covering up these heinous crimes. And members, you need to know the level of evil that we're talking about here. because it is literally beyond what you would ever imagine. And I'm going to share with you just one mother's testimony. I've redacted names and personal information. Hello, my name, she says. I am the mother of a 4-year-old that was sexually assaulted.
Members, this is such a serious topic, and the testimony has been so tragic. I would ask everyone to sit and not be in discussions. Thank you very much.
Thank you, Mr. President. I'll start again. Hello, I'm the mother of a 4-year-old that was sexually assaulted, and she names the school district. He was sexually assaulted by his pre-K teacher. He told us about the incident on Halloween, October 31st, and we contacted the police department of that city on November 1st. He was interviewed at the CAC, the Child Advocacy Center, on November 1st. The teacher was put on leave. CPS was alerted, but literally nothing was done. We are sitting there at the CAC with the sheriff's investigator, and they tell us, my son stated that this was happening during recess, that he was being held back in recess with another little boy, and she names him. She continues, as he was being interviewed, the sheriff let us know that the school resource officer, who worked for both the sheriff's department and the principal, had reviewed the video, and the video corroborated my son's claim that he was being held back in recess with this other little boy. That video was then deleted. The school district, she continues, deleted the video that corroborated my 4-year-old's testimony that this teacher, his teacher, had done this. This teacher, and excuse this, prepare yourself for this sentence. This teacher did not only just touch him, she sodomized him, a 4-year-old. So I watched the light of my beautiful, happy little boy go out in an instant, because there are sick predators in our schools, and this bill is needed to rid those predators. The school district put her back in the school the following year, brought her back in to teach the most vulnerable students, pre-K students. They closed our investigation, the school, before they even interviewed the teacher. And I'll let that sink in for a minute. Members, these child sexual predators and those who enable them currently operate behind an impenetrable shield called sovereign immunity. I would go so far as to say that many consider it sacred immunity. Members, what is sacred is the innocence of a child. I was not aware before I began working on this bill, which I'm grateful to Representative Little over in the House for bringing, that actually, currently, our schools do not have absolute sovereign immunity. That may be new to you like it was to me. But the immunity that they have is mostly confined to incidents with motor vehicles and property. With that said, how is it that a school can be held civilly liable with regard to a motor vehicle or property, and not for purposefully covering up the sexual abuse of a child entrusted to their care. After we, the committee, heard testimony, we took a couple of days to think about it. But we voted out the bill that you have before you here, the committee substitute to House Bill 4623, unanimously. House Bill 4623 will increase accountability in Texas public schools by allowing civil liability when a school is grossly negligent, reckless, or enables intentional misconduct in hiring, supervising, or employing individuals who commit sexual misconduct or fail to report suspected abuse. The bill applies to all public schools, including open enrollment charter schools. It covers a broad definition of a professional school employee, encompassing administrators, teachers, certified bus drivers, and board members. It creates a new cause of action that waives governmental immunity for schools and abolishes official immunity protections for employees in those cases. In those cases, ensuring that survivors can bring claims in court. The bill caps damages at $500,000 per claimant, and it guarantees the recovery of court costs and attorney's fees. I think that it's really important, members, that we do what we've done in the bill by tying liability directly to institutional failures and individual accountability. House Bill 4623 sends a message to the whole state of Texas, to all of our schools, to all of those who are in the sound of my voice. In Texas, school safety is a non-negotiable. The innocence of a child is non-negotiable, and schools will face serious consequences if they fail to protect our children. Members, House Bill 4623, as I said, passed unanimously out of committee, and it is my prayer that it will also do so on the floor here today. I move to suspend.
Senator Betancourt, what purpose?
Ask a question of the author.
Do you yield?
I want to congratulate you for taking this on. It's terrible what we heard. The stories are horrible, life-changing, negative, and forever scar the children that become adults, and hopefully we don't lose too many in the process that take their own life. At the same night we heard this, Mr. Chairman, you remember, Senate Bill 571, which was the last set of all the loopholes I know in the do not hire registry, was placed on the House calendar, and it just passed 134-2 today in the House. I hope this bill passes unanimously. We've, between plugging every hole that we know of on keeping our children safe from obvious pedophiles and predators out there, it begs the point, Mr. Chairman and Mr. President, during this hearing, we heard testimony that there was one person that had 24 years of service in the ISDs of the state. I say the word service in complete irony. They had 15 different employees Mr. President. And so we stopped the meeting, courtesy of the chairman, and asked TEA to come up and say, why has somebody with all these allegations over 24 years have, it takes until finally 2024, it started in 2000, finally in 2024, they got pulled, their license got pulled. That's why it was so important in 571 that we talked about the bill that's passing. It says that if there is an immediate threat, the commissioner can put somebody on the list, because that guy was an immediate threat for 24 years. And it's infuriating to me. And I exhorted the commissioner of TEA to do better, to do more, faster, quicker. Get these people on the roll, on the do not hire registry, and get them out of our schools, our public schools, our private schools, any place that they can touch a child. Because we're done with this now. We've got 2 fantastic pieces of legislation. We've got a do not hire registry that we've now worked on for 8 years, 6 years on the registry. Been at this for 8 years since, Mr. President, you gave me the assignment of stopping passing the trash in 2017. And I just want everyone in education to understand that the combination of these 2 bills makes it impossible to look the other way. And if you know something, you have to tell something at this point. Because otherwise, a lot of bad things happen. And now we can put these predators on the do not hire registry as fast as Commissioner Morath can get them there. And with this bill, it makes severe consequences for the ISD, because what we heard was a pattern of just absolute recalcitrant criminal behavior, in my opinion, hiding the ball, videos deleted, people looking the other way on purpose. Well, a child never gets a second chance. And these adults have to know it's over in the public education system. And not only do they need not apply, they need to realize that everybody now, between these combination of these 2 bills, is on record. You must report. You have substantial criminal penalties if you don't. The school districts can suffer tremendous financial loss. And I'm not talking about money, I'm talking about reputational risk, because the next bill up, Mr. President, we're talking about A through F. And if school systems, don't get this bill and take it to heart, that's going to be the next thing that gets added in the registry, because that public needs to know the same stories we hear. Senator Mendez, Senator Kolkhorst, and Education, Senator Creighton, we hear it year after year. And the burden that falls on the child that survives it is incredible. So I want to commend you for taking that burden on, Senator Paxton. And the good news is the combination of these bills passing means this will happen a lot less, and maybe someday not at all. Because that's the message that we are going to keep our school children safe by any means necessary, and that's what this bill does.
Thank you, Senator Betancourt.
Senator Menendez. For what
Question to
purpose?
the author, Mr. President.
Do you yield?
I do.
Thank you, Mr. President. Thank you, Senator Paxton. First of all, thank you for your persistence, your candor, your commitment to the kids of Texas. One of the questions that I brought up, I wanted to bring up because Senator West is not able to at this moment, is that he had mentioned, and he'd talked to me about the potential for possibly expanding the statute of limitations. I'm not sure if it got addressed in the amendment in the committee sub, because one of the concerns that he and I talked about is, what if a child were to be abused, 8th grade, high school, and they repress and they don't want to talk about it and they're afraid of reputation, what problems, and maybe after they're
senior year, they graduate, they come forward. I'm concerned do we know if the statute of limitations issue has been addressed, or is that something you're still working on?
This bill doesn't do anything different to address the statute of limitations. I believe it's 30 years.
Is it 30?
Yes,
Okay, great.
currently. And this doesn't alter that in any way, but I am incredibly interested in pursuing what that might look like and updates we might need to make on that.
Well, I was just making sure that I'm glad it's 30. We were concerned that it was a smaller time frame. He thought it was a shorter time frame, and so I wanted to make sure that we wouldn't close the door on any victims who are currently or maybe, God forbid, going through this or going to go through this, and all of a sudden they don't want to come forward till a few years later. So,
well, I appreciate the concern around this, and it's a very important thing to understand and address, because we do know that childhood sexual abuse is very unreported for a lot of reasons. But we also know psychologically many children repress these kinds of things.
yes.
And sometimes do not remember until they're adults. Many times when they have their own child who is the age at which they were abused,
right.
It triggers them, and you can only imagine what kind of trauma that would bring into the adult's life from that previous time. So it's an important issue, and I'm very interested in that issue in and of itself.
Well, I appreciate you taking my questions. Thank you for bringing the bill. Thank you, Mr. President.
Thank you, Senator.
Senator Hinojosa? What purpose?
Well, Senator, yield for questions. Thank you, Mr. President, and thank you for bringing this bill and being so persistent on this issue. But just to put it in proper perspective, just follow up on Senator Bendecourt, for many, many years, we have tried to focus on pass the trash. Teachers that had sexual misconduct records who would be allowed to resign, move on to another school. And it happened again and again, and the administrators would look the other way. And I know for years we have tried to close those gaps, and we have been successful, but not quite. There's still something missing, and there's something missing your bill addresses, and that's like putting the handcuffs finally on this issue that's very prevalent, even up to now. You pick up the newspaper and you read about a coach abusing a student. You read about a teacher abusing a student. But it's not only in public schools, it's also in private schools, charter schools, all across the board. And to me, it's been very frustrating that as many laws as we pass, placing some of these teachers on the register, school districts still continue to find ways to get around it one way or the other. But when you hit the pocketbook, and when you hit the reputation, and let the public know that it's going to cost the taxpayers money, and see, pull the sheets back, open the windows, open the curtains, so the parents and the community can see some of these abuses that are taking place, where many of our leaders and many of our public schools are not addressing, taking action. And this really is a very important bill in trying to get the attention that we will not tolerate this type of abuse anymore. But just thank you for your legislation, and God, thank you for your persistence in bringing this bill forth. Thank you.
Thank you, Senator. And you bring up traditional public schools and charter schools. This bill covers both of those. It does not address private schools, but private schools don't have sovereign immunity. So they are already open to this sort of litigation. It does close the gap, and I'm thankful for your support. I'm thankful for the strong bipartisan support that I have seen in this body on this topic in general, but especially on this bill. I know that many folks, when they first read the bill, they thought, oh, this is going a little too far. That sacred sovereign immunity, this is going too far. I know members on the committee felt that way to some extent. But that is why I read for you the testimony. because no one should be able to hide behind sovereign immunity for doing something like that. And can you imagine a family who has nowhere to go? They know that school has been complicit in harming their child, and they had nowhere to go with it. That won't be true anymore. And accountability is good for all of us. Transparency is good for all of us, but the biggest winners are going to be our kids.
A very good point. Sovereign immunity does not apply to private schools. Thank you.
Thank you.
Members, the motion is on suspension of the rules. Any objection? Hearing none. Rules are suspended. Chair lays that on the second reading. Committee substitute for House Bill 4623. Secretary, read the caption.
Committee substitute House Bill 4623 relating to liability of public schools and professional school employees for sexual misconduct involving students.
Members, there is an amendment. Following amendment. Secretary will read the amendment.
For amendment number 1 by Paxton.
Senator Paxton, you're recognized on your amendment.
Thank you, Mr. President. You may be thinking this looks like a long amendment, as long as the bill, and that is true. It does two things. It is a ledge council draft of the bill, so that's why it looks just like the bill. And it changes one word. It replaces the word money with the word actual, referring to damages, actual damages reflective of common legal terminology. I move adoption of floor amendment number 1.
Any objection? Hearing none. Amendment is adopted. You're recognized on passage to third reading.
Thank you, Mr. President. I move passage to third reading.
Any objection? Hearing none. Bill passed to third reading. You're recognized to suspend the constitutional 3-day rule.
So moved.
Secretary will call the roll.
Alvarado, Betancourt, Bogo.
31 ayes, no nays. Rule suspended. Chair lays out on third reading and final passage. Committee substitute for House Bill 4623. Secretary, read the caption.
Committee substitute House Bill 4623 relating to liability of public schools and professional school employees for sexual misconduct involving students.
Before you close, thank you, freshman Mitch Little, for bringing this bill. And I can't think of a better senator on the floor who could have handled this, Senator Paxton, than you. Eloquent in your words. For all of those in the schools, our thousands of superintendents, 1,000 or more superintendents, thousands of principals, understand we're going to be watching, and your careers will be destroyed. You could end up in jail. We're not going to tolerate this one more day. I can't think of a time in my 20 years and 10 sessions that the floor has been so quiet and listening to every word. I can't think of another time that our hearts have really been hit by a bill. And we've been through a lot of tough times in 20 years. I'm going to ask the commissioner to not hesitate for a moment to move personnel to focus on this issue. I don't want to hear they don't have enough people. I don't want to hear they don't have enough time. They need to be on it. And members, I'm going to recommend to the commissioner that they send in a special delivery envelope to every principal in the state and to every superintendent in the state this bill and the other bill that Senator Betancourt has passed. I don't want any excuses that they didn't know, they didn't see, they didn't understand. So I want the commissioner, special delivery, Commissioner Morath, as soon as this session's over, before the next school year, on the desk of every principal in the state and every superintendent. No more excuses. You're recognized on final passage.
Thank you, Mr. President. Thank you, Representative Little. You're a good friend in so many ways, and you're a great representative. Appreciate you. Chairman Creighton, thank you for locking arms with me and helping push this through to the end. Members of the committee, thank you for listening. Thank you for listening and not making up your mind before. Members, thank you for listening. You know, I have a 4-year-old grandson. And when I go to their house, I sit him and my 2-year-old grandson on my lap, and I read them a story. And I hug them. That's what you do with children. That's what you do with children. And so, yes, Senator Bettencourt, pedophiles need not apply. And administrators, we need you to do your job. We know it's a lot, but there is nothing more important than protecting our children. Thank you. And thank you, Mr. President, for your strong statement about implementing this and making sure that it becomes actual in the state of Texas. I move final passage.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell.
The bill finally passes 31-0. Thank you, Senator. Senator Betancourt, you're recognized. Suspend the regular order of business. Committee substitute for House Bill 4.
Thank you, Mr. President. What gets measured gets fixed. And in 2017, during the 85th legislative session, this body passed HB 22, which established the current A through F rating system for Texas public schools. Since the passage of HB 22, only one full accountability year ratings have been released. That was 2019. In 2021, I authored and we passed in the Senate as well as the House to address the Third Court of Appeals ruling and ensure continued operation of the accountability system and the intervention process. Over the last 2 years, these ratings have been blocked by being released by repetitive taxpayer-funded ISD litigation, Senator Middleton. In fact, the lead plaintiff, Kingsville ISD, until the 15th Court of Appeals ruling just released the fact that they have a F rating. And we did know that, but we do know that they sued both 2023 and 2024. There's still the 24 case to go, but as of this year, April 17th of this year, we sent Senate Bill 1962, my A through F accountability legislation, back to the House. In fact, most of this bill, going back to my House partner, Chairman Buckley, is based on that bill. And on the floor of the Senate, we had 4 amendments that really improved this legislation. We removed low expectation factors that applied to districts who participate in lawsuits. We removed the requirement that legal fees pertaining to suits against the state be held in escrow. We replaced the direction of the Commissioner of Education with shall to appoint conservators to may. We honored the performance agreements made between TA and charter schools that took proactive measures in absence of A through F ratings. In addition to that, we've added 2 more good items. We added avenue for districts to challenge agency rules with state revenues, and we provided a simplified ability to districts to end their turnaround performance plan if their performance has gotten on track. But wait, Mr. President, there's more. HB 4 will now ensure that A through F rankings are available to the public that will show a public accountability system. We prohibit using taxpayer funds to pay for these lawsuits, but however do allow them to use taxpayer funds for rule challenges. We'd also will not assign not rated anymore in our A through F ratings. And we set the following high expectations because members, we're going to get rid of the STAR test. All right? You ready? We're going to get rid of the STAR test. And on the way to that, we're going to have students included in military readiness indicators. We've got overall college career military readiness in the bill. We've got industry-based certifications in the bill. We allow the commissioner to exclude invalid or invalid or unreliable indicators from the accountability system, and charters have their accountability systems intact through the 2023-2024. But wait, we're not done yet. We're going to get rid of the STAR test, and we're going to replace it with something even better. 3 tests, Senator Menendez, a beginning test, a middle test, and then a final test, and get rid of this incredible anxiety that we're seeing on the last test. With, I hope, and we're going to have my partner, Chairman Buckley and Chairman Creighton have talked about this, to talk about what a new test structure looks like. And I think we could have an automated first 2 versions of that, and then a final test that's more like the one the kids taste now. And the important thing is we're going to have a 3-year phase in. So all of this is going to be done when we refresh A through F. And we're going to have tremendous pilots in the field in the 2nd year on this so that we don't overuse benchmark exams ever again. And we're going to provide training to teachers in using the test. So what I'm really excited about here is the initial and middle and final test. So with that, members, I think we've got a great bill, and I think we're going to have a great discussion with our House counterparts. And with that, I move to suspend the regular order of business and take up the committee substitute to House Bill number 4.
Senator Menendez, what purpose?
Questions of the author, Mr.
Do
President?
you yield?
Certainly.
Thank you, Mr. President. Thank you, Senator Betancourt. So, Senator Betancourt, the House Bill 4, as it came over from the House, was the way to get rid of the STAR test and replace it with the norm test, correct?
Sure. Both bills had that in the pattern, but yes.
Okay. And then my understanding is that the committee substitute for HB 4 has the language out of SB 1962 that came off the floor earlier this session.
That's right, with the 4 last amendments plus 2 additional ones, and then the beginnings of the outline of the initial beginning, middle, and then the final test.
Correct. And I'm 100% for the getting rid of the STAR, 100% for these norm tests. I've got a little bit of concerns, but I think you're addressing them. The concerns I've had with SB 1962 are serious because I'm concerned how we understand the legal system when it relates to the education system. And I was just wondering, is there still a provision that triggers a TEA takeover if a district decides to sue over the A through F ratings?
Well, there is a provision that there is a may, okay? The old provisions were shall, that's all been removed. And the may, I think, is based upon really severity of what we're dealing with. I think that's a good step. The frustration with all of this is that we have millions of students in public education. And we have a handful of schools, down to 30 on that last suit, that just continue to keep suing and suing. And the lead plaintiff, Kingsland ISD, has got an F. And it's obvious that maybe they don't want these, accountability ratings out in public. So it's time to blast past that, but give the schools a chance to use public money on rules challenges. And I want to point out there's other people that have intervened in this by using their private dollars. So that's not a completely novel, okay? Because you've got trustees doing that as well. We took testimony, as you remember, from one superintendent that said that his total bill for all of this was $3,000, but I'll tell you, the total bill to the state was a lot higher in lost scores that could have told public what's happening, families what's happening, students what's happening, and that's really the genesis of the bill.
And I welcome accountability. I think accountability is important. I think we, as taxpayers, and especially us as policymakers who represent each of us 1 million people, it is incumbent upon us that we are transparent and that we require the best, that we fully empower our school districts and then ask them to produce the best product possible. So I'm not opposed to that. I'm just concerned that we produce a bill that might coerce people or feel like they're coercing them. And let me give you an example. If in committee we saw that a school district that maybe have been graded a B, but still felt the commissioner didn't do the right thing, maybe the metrics they chose or the timing that they released things or anything else that they could feel wasn't a right fit under the bill, if they still, under your bill, if they were to sue, you're telling me it wouldn't necessarily trigger a takeover, but they could take over?
It's a may. Now, let's go. We had testimony from,
right.
I think actually the school district we're talking about, not by name, they had a B ranking for 2023.
Yes.
And I asked repetitive questions about why are we suing about over a B ranking? Okay?
Agreed.
And the only answer I got was clarity. We need more clarity. Well, if you need to sue over rules, because that's what TEA does, they write rules for clarity, you can do that with public funds. What we can't do is Groundhog Day, we're wake up the same day at 6:01 a.m., and we're back not having a public accountability system. So I think that message is clear, but it's possible that, we could get something horribly wrong, and so we have to recognize from the state's perspective that we allow it, but also it's time to stop this repetitive blockage of numbers. There's so much collateral damage that occurs. So, communities don't know how their schools are going. And, and I'm worried because I've heard that one school district that we had a B, they have substantially fallen. Okay. And I just think it's time that let's get all this transparency back on the table, because what gets measured gets fixed.
Yeah, I understand and agreed completely with that. My concern that if TEA comes in and does a takeover of the school district and there's no judicial impact, then TEA now runs the school district. They could pull out of the lawsuit and in essence not allow for the school district to have a voice. It seems like we're creating an unfair legal process. Let's move on.
I could just make a quick comment.
Please, go right ahead.
There's always third parties in these suits, okay? Now, I've learned to say never around here, even though I say what gets measured gets fixed. I would consider that scenario unlikely because there will always be third parties as part of the suit. You know, and that's really what I described. There's already individual trustees that are spending their own personal money as individuals in these suits. So I would say that would be a statistical, anomaly if it occurred.
Does your bill with its amendments, does it allow the school boards to elect to use school district funds for their lawsuits?
For which lawsuit?
For a lawsuit, if they were to file the lawsuit.
Yeah, on any rules.
Okay.
Okay, right.
Okay. Well, that's good. Let me see here. We talked a little bit about when you questioned the superintendent for the last lawsuit, and we talked about a second ago, $3,000, far less. It's interesting. I would think if the community could hold their district accountable, we shouldn't be concerned about preempting their use of funds. And so I think you've taken that out where they can use their own funds. Okay. And I guess finally, there is a concern when we get into the taking away legal remedies that we could be doing a separation of powers issues where we have the legislative branch and we're eliminating the judicial route for them to seek some remedy.
It's not eliminated.
Okay.
Okay. We're just saying we're at the end of our rope and understanding why we're using taxpayer money to do this.
Yeah.
But if there are rules problems, that's well within bounds to use taxpayer money on it.
Okay. And so this bill is going to go back with some additional legislation in there. I guess you've spoken to Chairman Buckley.
Certainly.
How does he feel about the new version?
Well, he likes the new version and is anxiously awaiting its arrival.
It'll be good.
He likes the new version better than the old version, at least the old Senate version. That much, I'm sure he's got great pride in his HB 4 too. But we'll be looking forward to have a good discussion with him.
Sounds good. Thank you for answering my questions. Appreciate it.
Thank you, Senator.
Senator Hancock, what purpose?
I'd like to ask a few questions.
Do you yield?
Certainly.
And Senator Bettencourt, you know my passion for education.
Absolutely.
History. My dad served school board 12 years, brother 7, I served 13.
That's a combined 32 years in the family, almost a third of a century.
You know how many times on this floor I have stood against anything that I felt like would lower any standards or requirements or hopes or expectations for students within the state of Texas?
How many times you stood to lower hopes and expectations?
No,
I would assume that's
opposing the lower.
Yeah, well, I would assume that number's 0.
Correct.
Okay, right. Okay.
I'm going to be supporting House Bill 4. Are you also aware of the recent letter given to Fort Worth ISD?
Yes, I have heard about it. Okay.
But one of the ways that we were able to spot the decades-long loss of dreams, loss of futures, of killed children, and now many, many adults within my district, was the accountability standards that were established by the state of Texas, that after decades and decades and decades of underperforming, of letting thousands of kids down, thousands of families down, thousands of parents down because they were not performing, and then we were able to capture that through the STAR test, which I get incredibly unpopular, which most accountability standards are, by the way.
Sure, because eventually they wear out their welcome.
Well, most people don't like being held accountable, especially when it comes to education. And I think it is our role, our job, our responsibility, especially when we're using someone else's money, taxpayer money, to require that accountability. Would you agree?
Absolutely, and I seem to remember that that school district was active at times in the past in a great many things, except concentrating on their business, which was to educate the students of their district.
In fact, we had 2 extra years beyond when the state should be doing what they're doing because of lawsuits using taxpayer money suing the state, where during those 2 years we saw no improvement in performance. The same thing was happening, except they were suing the state saying, let us continue to let down these children the way we've let them down for the last 2 or 3 decades.
Right, and when the lead plaintiff has an F ranking, you wonder why they sued. Well, there's no wonder, because they were an F. They didn't want the public to know, in my opinion.
And that gets to where I am at here. We've invested a lot of taxpayer dollars in developing the STAR text.
Sure.
And I believe that the information it provides is good information. And assessments have been made. We would not be where we're at in saving the students in Fort Worth ISD had it not been for that accountability system.
Sure. That's why we're going to take the best of it forward.
And so I know what we're doing is highly popular with our voters. But my concern, my passion is for those children that will one day be voters, and I want them to be well-educated voters with high expectations from the elected officials
High
here.
educational attainment.
And so while I'm with you, I want a commitment that there's no lowering of the standards, there's no lowering of the expectations, and there's no lowering of the dreams. And the assessment tools that we're going to need as those responsible for taxpayer monies, where half of what we spend here goes into education.
Absolutely.
We have to have a strong accountability system that, frankly, whether people like the accountability system or not, is not as important as is it good, does it work, and is it accurate, so that we can assess. And so I want a commitment that as we make these changes, we're not going to lower any of that, and we'll still have an assessment tool that we can count on and that has high expectations, so that Texas can be the #1 education state in the United States if we're going to transition and we're going to go this way to make people feel happy. I'm fine when they feel happy as long as the information's accurate, it's good, and it helps Texas move the youngest that we're responsible for in the state of Texas to become the #1 education state in the country. Do I have that commitment?
You're talking to the man whose favorite saying is, what gets measured gets fixed. Now, yes, you have that commitment, and I'm so excited by the outline of what we see in this testing, okay? That will have a lot more detail as the bill comes back from the House. I'm very excited about some of this modern item level testing that you could do on initial test and midterm effectively test, that the teachers get feedback like that, and they know where the kids are going.
I'm very familiar. I'm very familiar.
I'm making sure everybody that's not as familiar as you and the rest of us, and then we're going to take the best of that, the STAR criterion test, okay, and make sure that make sure that we bring that forward, okay. And I'm really excited about the 1, 2, 3 testing schedule. I think we're finally getting it right. And importantly, the educator's going to have a lot more access to information, because when you go down these item level tests, you know there's about 1,000 questions you could ask. So TEA is going to have to spend the time really driving these test beds, looking at these questions. And we looked at trying to just jam this through within 2 years. Senator Creighton and I talked about it. There's no reason to do it. I'd rather have a full-blown, serious pilot plan in year 2, and then we can walk into what I think will be a really good implementation in year 3.
Thank you. Thank you, Senator Bettencourt, and thank you, Mr. President. I know why we're doing this, but I'm much more concerned in getting good, accurate information to help us improve our educational system than I am making sure everybody feels good about themselves.
Right. Accountability is accountability, period.
Right.
Okay? And that's the stand that we're taking, and that's something that you can't compromise the hopes and the dreams of the future on.
Thank you. Thank you, Mr. President.
Thank you, Senator. Accountability is important. We spend a lot of money in education. We want the results for sure. Senator Bettencourt, the Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell.
23 ayes and 8 nays. The rule is suspended. Chair lays out on second reading. Committee substitute for House Bill 4. Secretary will read the caption.
Committee substitute, House Bill 4, relating to the assessment of public school students, public school accountability and actions, and proceedings challenging the operations of the public school system.
You recognize and pass the third reading.
Thank you, Mr. President. I move passage to third reading of the committee substitute to House Bill 4.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco.
23 ayes and 8 nays. The bill passed the third reading. You'll have to find 2 friends.
I will do my endeavor right here. Thank you, but thank you everyone so far for the really intelligent debate. I really appreciate it. Thank you, Mr. President.
Eight. They're all Ds.
Members, on our bill 4623, Senator Paxton, just so you don't tweet out by mistake 31-0 unanimous, Senator Eckhart changed her vote to a no vote on 4623, so do not send out that it was unanimous vote by error. Senator Campbell, you're recognized on House Bill 3749. It's been the regular order of business.
Thank you, Mr. President. House Bill 3749 restricts physician delegation for elective IV therapies to only RNs, APRNs, and PAs. This bill passed the House 132-2. And with that, Mr. President, I move suspension of the regular order of business.
Any objection? Hearing none. The motion is adopted. House Chair lays out House Bill 3749. Secretary, read the caption.
House Bill 3749 relating to the regulation of the provision of elective intravenous therapy.
You recognize passage to third reading.
So moved.
Any objection? Hearing none. Bill passes to third reading. You recognize suspend the constitutional 3-day rule.
So moved.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell,
31
Blanco.
ayes and no nays. The rule is changed, suspended, there we go. Chair lays out on third reading and final passage, House Bill 3749. Secretary, read the caption.
House Bill 3749, relating to the regulation of the provision of elective intravenous therapy.
You're recognized on final.
So moved. Final
Secretary will
passage.
call the roll.
Alvarado, Bettencourt, Birdwell, Blanco.
31 ayes, no nays. The bill is finally passed. Thank you.
Thank you, Mr. President. Thank you, all members.
Senator Middleton, suspend the regular order of business. I thought that was your last bill. House Bill 100, suspend the regular order of business.
Thank you, Mr. President. Got a few more to go here. House Bill 100, sorry, need to lay out that motion there. I move to suspend the regular order of business, take up and consider House Bill 100. House Bill 100 reaffirms the role of the State Board of Education in maintaining academic quality in Texas public schools by aligning local instructional material decisions with the outcomes of the state's review process. This builds on House Bill 1605, enacted in 2023, which created the Instructional Materials Review and Approval Process, IMRA, to evaluate whether educational resources meet Texas Essential Knowledge and Skills, TEAK standards, and English Language Proficiency Standards, which is ELPS. While the IMRA process allows the SBOE to designate materials as approved or rejected, current law does not prevent school districts from adopting materials that have been formally rejected. HB 100 addresses that gap. The bill prohibits public schools from adopting or using any instructional materials that appear on the State Board of Education official list of rejected materials, and this includes open educational resource materials. HB 100 also amends the instructional materials and technology allotment statute to ensure that state funds cannot be used to purchase rejected content and to provide transparency. The bill requires the SBOE to issue a 45-day notice before final rejection and allow time for publishers to make revisions and cure. Additionally, it clarifies that even with local funds, districts may not purchase rejected materials. And with that, I move suspension.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco.
27 ayes, 4 nays. The rule is suspended. Chair lays out in second reading House Bill 100. Secretary will read the caption.
House Bill 100, relating to the purchase, adoption, and use of instructional materials by public schools.
Following amendment. Secretary, read the amendment.
Floor amendment number 1 by Middleton.
Senator Middleton, on your amendment.
Thank you, Mr. President. Members, this amendment pushes back the school year that the bill will apply to the 2026 through 2027 school year to allow them more time. This gives districts a school year to transition out of any rejected instructional materials they may have already purchased. Additionally, the amendment adds clarifying language that the bill applies to any rejected instructional materials that are maintained or added to the rejected material list on or after the school year in which this act applies. And I move adoption.
Any objection? Hearing none. Amendment is adopted. You're recognized to passage to third reading.
So move, Mr. President.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell.
27 ayes, 4 nays. The bill passes to third reading. You're recognized to suspend the constitutional 3-day rule.
So move, Mr. President.
Secretary will call the roll when ready.
Alvarado, Bettencourt, Birdwell, Blanco.
27 ayes, 4 nays. Rule suspended. Chair lays out third reading and final passage. House Bill 100. Secretary, read the caption.
House Bill 100, relating to the purchase, adoption, and use of instructional materials by public schools.
You're recognized on final passage.
Move final passage.
Secretary will call the roll when ready.
Alvarado, Bettencourt, Birdwell, Blanco.
27 ayes, 4 nays. The bill is finally passed. Thank you. Senator Sparks, you're recognized to suspend the regular order of business. House Bill 5629.
Thank you, Mr. President. I move to suspend the regular order of business in order to take up and consider House Bill 5629. Members, House Bill 5629 streamlines the professional licensing process for veterans, military members, and their spouses in Texas by allowing them to obtain a Texas license more efficiently and recognizing their out-of-state licenses, simplifying residency requirements. With that, I move suspension.
Any objection? Hearing none. Rules are suspended. Chair lays out on second reading House Bill 5629. Secretary, read the caption.
House Bill 5629, relating the occupational licensing of military service members, military veterans, and military spouses.
You're recognized on passage to third reading.
I move passage to third reading.
Any objection? Hearing none. Bill passed to third reading. You're recognized to suspend the constitutional 3-day rule.
So moved.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell.
30 ayes, 1 nay. The rule is suspended. Chair lays out third reading and final passage. House Bill 5629. Secretary, read the caption.
House Bill 5629, relating the occupational licensing of military service members, military veterans, and military spouses.
You're recognized on final.
Thank you, Mr. President. I move final passage for House Bill 5629.
Secretary will call the roll.
Alvarado, Bettencourt,
30
Birdwell.
ayes, 1 nay. The bill is finally passed. Thank you.
Thank you, Mr. President. Thank you, members.
Senator Parker, you're recognized to suspend the regular order of business on House Bill 640.
Thank you, Mr. President. I'm going to suspend the Senate's regular order of business to take up and consider House Bill 640. This is a very simple bill, but provides important clarification for local election authorities about what constitutes a regular business day during election periods, particularly when those days fall on recognized holidays. HB 640 makes clear that local election offices may close on holidays that fall on weekdays during an election period, just like school districts. This provides clarity, consistency, and fairness to all election authorities and their employees. Mr. President, I move suspension.
Any objection? Hearing none. Rules are suspended. Chair lays out on second reading House Bill 640. Secretary, read the caption.
House Bill 640, relating the office hours of an election authority during an election period.
You're recognized on passage third reading.
Thank you, Mr. President. I move passage to third reading.
Any objection? Hearing none. Bill passed to third reading. Recognized to suspend the constitutional 3-day rule.
So I move, Mr. President.
Secretary will call the roll.
Alvarado, Bettencourt.
31 ayes, no nays. The rule is suspended. Chair lays out third reading and final passage. House Bill 640. Secretary, read the caption.
House Bill 640, relating the office hours of an election authority during an election period.
You're recognized and final.
Thank you, Mr. President. I move final passage.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell.
31 ayes and no nays. Bills.
Thank you, Mr. President, members.
Members, we plan to go to about midnight tonight. The intent calendar closes at 8, so we're going to keep passing bills till 8, and we'll take about a 20-minute break at 8 o'clock for the ladies particularly.
Senator Zaffarini recognized for a motion to suspend the regular order of business on House Bill 705.
Thank you, Mr. President. Mr. President, members, I move to suspend the Senate's regular order of business in order to take up and consider at this time House Bill 705 by Representative Terry Wilson. It relates to the Cosmetology Licensure Compact. Members, this bill generally would enact the Cosmetology Licensure Compact that allows eligible cosmetologists licensed in one member state to practice in other compact states without needing additional licenses, subject to requiring member states to meet uniform licensure criteria, including education, examination, and background checks, and to share licensure and disciplinary data with the Compact Commission. In other words, it's based on reciprocity. It also would designate TDLR as the compact administrator for the state and authorize the Texas Commission of Licensing and Regulation to adopt necessary rules. There will be a floor amendment that is a clarifying amendment requested by Representative Wilson to address concerns raised by the governor's staff. The amendment would provide that the purpose of the compact is to facilitate multi-state licensure of cosmetologists and that no member state shall be subject to any laws, rules, or regulations of any other state beyond this intended purpose. It would clarify that the bill would not prevent or inhibit the enforcement of any other law of a member state and provide that all permissible agreements between the Texas Commission of Licensing and Regulation and member states are binding in accordance with their terms. Mr. President, I move suspension.
Senator Zaffarini moves suspension of the regular order of business on House Bill 705. Is there objection? Hearing none, the rules are suspended. Chair lays out on second reading House Bill 705. The Secretary will read the caption.
House Bill 705 relating to the cosmetology licensure compact.
Is there a minute? Following amendment. Secretary read the amendment.
Floor amendment number 1 by Zaffarini.
Senator Zaffarini, you recognized.
Thank you, Mr. President. Mr. President, members, this is a clarifying amendment requested by Representative Terry Wilson that I described in my opening statement. It addresses concerns raised by the governor's staff. Mr. President, I move adoption.
Questions on the adoption of floor amendment number 1? Is there any objection? Hearing none, amendment is adopted. Senator Zaffarini, recognized for a motion.
Thank you, Mr. President. I move passage to third reading.
Senator Zaffarini moves passage to third reading. Is there objection? Hearing none, the bill is passed to third reading. Senator Zaffarini, recognized for a motion to suspend the constitutional 3-day rule.
Thank you, Mr. President. I move to suspend the constitutional rule that bills be heard on 3 several days.
Senator Zaffarini moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco.
31 ayes, 0 nays. Rule is suspended. Chair lays out on third reading. Final passage, House Bill 705. The Secretary will read the caption.
House Bill 705 relating to the cosmetology licensure compact.
Senator Zaffarini, recognized for a motion.
Thank you, Mr. President. I move final passage.
Senator Zaffarini moves final passage of House Bill 705. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
31 ayes, 0 nays. The bill is finally passed.
Thank you, Mr. President and members and Representative Wilson.
Senator Parker, you're recognized for a motion to suspend the regular order of business on committee substitute for House Bill 3783.
Thank you, Mr. President. I'm going to suspend the Senate's regular order of business to take up and consider the committee substitute for House Bill 3783. What some call reunification therapy is a pseudotherapy that claims to repair the relationship between a child and their non-custodial parent. However, this unregulated practice often involves forced overnight or out-of-state stays for children away from their custodial parent, using private transporters that engage in force and threats, so-called therapies that are not evidence-based, and the use of physical threats or coercion or isolation of the child. This purported treatment alleges that it can rebuild relationships between children and an estranged parent, but it tries to do this by traumatically breaking the relationship between children and their primary custodial parent through no-contact orders, physical abduction, and removals to camps, and threats of consequences of reporting noncompliance back to the court. These are not custodial parents who are involved in a CPS case or have been investigated by the state for abuse or neglect. These are typically normal, loving parents who often during the separation from an abusive partner face further abuse that isolates them from their children with little to no oversight. If a court wants to order therapy between the non-custodial parent and the child, the court can do so, but they cannot make a removal or a no-contact order against the custodial parent for that therapy. That decision to be made in the course of a true custody hearing, not through the back door of therapy. I also want to thank specifically Senator Johnson and Senator Hughes for working with me on this bill to perfect it in committee. I think we have a very good bill in a good place. And with that, Mr. President, I move suspension.
Senator Parker moves suspension of the regular order of business on committee substitute for House Bill 3783. Is there objection? Hearing none. The rules are suspended. Chair lays out on second reading committee substitute for House Bill 3783. The Secretary will read the caption.
Committee substitute House Bill 3783 relating to court-ordered counseling in certain suits affecting the parent-child relationship.
Senator Parker, you're recognized for a motion.
Mr. President, I move passage to third reading.
Senator Parker moves passage to third reading. Is there objection? Hearing none, the bill is passed to third reading. Senator Parker, you're recognized for a motion to suspend the constitutional 3-day rule.
So moved, Mr. President.
Senator Parker moves suspension of 3-day rule. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook.
31 ayes and 0 nays. Rule is suspended. The chair lays out on third reading, final passage. Committee substitute for House Bill 3783. The secretary will read the caption.
Committee substitute House Bill 3783 relating to court-ordered counseling in certain suits affecting the parent-child relationship.
Senator Parker, you're recognized for a motion.
Yes, Mr. President, I move final passage. Thank you, members, for your support of this good piece of legislation. Thank you.
Senator Parker moves final passage. Committee substitute House Bill 3783. The secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco.
31 ayes, 0 nays. Bill is finally passed.
Thank you, Mr. President, members.
Senator Huffman, you're recognized for a motion to suspend the regular order of business on House Bill 5699.
Thank you, Mr. President. I move to suspend the regular order of business, take up and consider House Bill 5669. Members, a tract of undeveloped land within Harris County Municipal Utility District number 405 needs to be excluded from the district so that services can be provided by a neighboring district. I move suspension.
Senator Huffman moves suspension of the regular order of business. Senator Huffman moves suspension of the regular order of business on House Bill 5699. Is there objection? Hearing none, the rule is suspended. Chair lays out on second reading House Bill 5699. The secretary will read the caption.
House Bill 5699 relating to the authority of the Harris County Municipal Utility District number 405.
Senator Huffman, you're recognized for a motion.
I move passage to third reading of House Bill 5699.
Senator Huffman moves passage to third reading. Is there objection? Hearing none, the bill is passed third reading. Senator Huffman, you're recognized for a motion to suspend the constitutional 3-day rule.
So moved, Mr. President.
Senator Huffman moves suspension of the 3-day rule. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco.
28 ayes, 3 nays. The bill is passed to third reading. Senator Huffman, you're recognized for a motion to suspend the constitutional 3-day rule.
Members, I move final passage of House Bill 5699.
What are we on? Huh? What happened is we were supposed to take a roll.
Vote twice.
Oh, I see. I see. Well, what she had up there was.
Are y'all killing my bill? Y'all doing it?
Didn't stop when I was trying to do regular. So I said, forget it. I blew up the system. We did 3 days. So we're on final passage.
We're on final passage. Okay.
Final passage.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook, Creighton, Eckhart, Flores,
28 ayes and 3 nays. Bill is finally passed.
Thank you, members.
Senator Perry, you're recognized for a motion to suspend the regular order of business on House Bill 2078.
Thank you, Mr. Chairman. Members, House Bill 2078 is a DFC accountability. It brings districts together in the current planning process to make sure they're on task for their DFC goals 50 years out. With that, I move to suspend the regular order of business on House Bill 2078.
Senator Perry moves suspension of the regular order of business on House Bill 2078. Is there objection? Hearing none, the rules are suspended. Chair lays out on second reading House Bill 2078. The Secretary will read the caption.
House Bill 2078 relating to the joint planning of desired future conditions in groundwater management areas.
Senator Perry, you're recognized for a motion.
Move past third reading.
Senator Perry moves passage to third reading. Is there objection? Hearing none, the bill is passed to third reading. Senator Perry, you're recognized for a motion to suspend the constitutional three-day rule.
Move to suspend the constitutional three-day rule.
Senator Perry moves suspension of three-day rule. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco.
30 ayes, 1 nay. The rule is suspended. Chair lays out on third reading and final passage House Bill 2078. The Secretary will read the caption.
House Bill 2078 relating to the joint planning of desired future conditions in groundwater management areas.
Senator Perry, you're recognized for a motion.
Move final passage.
Senator Perry moves final passage House Bill 2078. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell.
30 ayes, 1 nay. Bill is finally passed. Senator Bettencourt, you're recognized for a motion to suspend the constitutional three-day rule.
So moved, Mr. President.
Senator Bettencourt moves suspension of the three-day rule. The Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell.
25 ayes, 6 nays. Rules are suspended. Chair lays out on third reading final passage committee substitute for House Bill 4. The Secretary read the caption.
Committee substitute House Bill 4 relating to the assessment of public school students, public school accountability and actions and proceedings challenging the operations of public school system.
Senator Bettencourt, you're recognized for a motion.
Thank you, Mr. President. On behalf of over 5 million students, their families, and the entire community of education in the state of Texas, I move final passage, committee substitute House Bill 4.
Senator Bettencourt moves final passage committee substitute for House Bill 4. The Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell.
23 ayes, 8 nays. Bill is finally passed.
Thank you, Mr. President and friends.
Members, we're going to take a quick break for staff, and a couple of committees are going to be meeting as well. Chair recognizes Senator Huffman.
Thank you, Mr. President. Members, I have a motion to suspend. I move to suspend the 24-hour posting rules so that the Senate Committee on Finance can meet in the Senate press room to consider House Bill 1057 today at 8:15 p.m. in the Senate press room. And members, Finance, I do need a quorum, please. Thank you.
Is there objection to the motion? Hearing none, the motion is adopted. Chair recognizes Senator Flores for a motion.
Mr. President and members, I move to suspend Senate Rules 11.10, 11.13, and 11.18 so that the Senate Committee on Criminal Justice can meet at the press room 2E19 today, Tuesday, May 27th, 2025 at 8:30 p.m. to consider House Bill 3664 as a matter of pending business.
Members, is there objection to the motion? Hearing none, it's so ordered. I recognize the Dean of the Senate for a motion.
Thank you, Mr. President. Mr. President, members, I move that the Senate stand in recess until 8:50 today, Tuesday, May 27th.
Members, are there any objection? Hearing none, so ordered.